Hi, a very good evening to today's marathon. Now, earlier we had taken a marathon, which was on JIGL marathon. I had covered a few chapters. Today we'll be covering some other chapters, and tomorrow again I will be taking a few more chapters, and then your entire syllabus will get over. Okay, so I have already done. Let me tell you the chapters that I have already completed. So I have completed Constitution of India, Interpretation and Civil Procedure Code, Limitation Act and RTI Act. So all these acts I have already covered in my last marathon. The link I have shared it in my WhatsApp group. You can also Google or your YouTube it. That is JIGL Marathon in English. We've covered all these chapters. Today I will be covering the other chapters. Okay, and then tomorrow one more day we have where I will be covering a few more other chapters. Remember one thing, that though this is a marathon, whatever I cover in depth all the topics, so that not a single question can be asked outside of it. So we cover the full thing. Only thing is we go a bit fast and I try to cover it in a faster manner. Okay. So today we will be covering few other chapters also. Let me tell you the topics for today. First, we will knock off some easy chapters but have 8-mark weightage, which is your torts, law of torts. I will cover today. I will be covering one evidence act. We will see evidence act also is pending, so this we will be taking also in depth. And when I'm taking the evidence acts, I will take the last. I will be taking it last today, and then before doing it I will just share the notes also with you all. Okay, then I will be covering few chapters which are very in demand. I can cover your Information Technology Act, that also will be covered today only. Okay, and one more, let me see a few more, but as and when I'm just telling you whatever it is there in line. Okay, so this is there, and so all this I have completed. Let me see which other chapter I can complete quickly. Let's say I'll also cover your Specific Relief Act, will also be quickly covered. Okay, it's a tough chapter but I'll make it really simple for you. Okay, but a short and sweet chapter or two. Okay, and we will see your Arbitration Conciliation Act also. It's very important chapter, 10-mark weightage, so that also we will be covering. So we start off with a pace where we can cover chapters much faster, and slowly in between we'll be doing some smaller chapters and some big chapters as well. Now before I start, I need you all to tell me in the chat box whether I'm audible, visible to all of you all, yes or no. Okay, just be with me, I will be covering everything. Okay, great. In the chat box, am I audible, visible? Okay, great. Sure. Good to go. Can we start? Yeah. Arun, great. Harish, Maria, competitive, great. Yes. So full syllabus. So I have already covered a few chapters. I will be covering more chapters tomorrow. I'll be covering more chapters. So more or less out of your entire 18 chapters, around, I could easily say around 8 to 10 chapters will be completed. Okay, 8, what I could say, more than that only, 12, 13 chapters will get completed. Okay, sure. So only few unimportant ones will be left. So that is where you can plan accordingly. Okay, so let's begin. GTG, great. GTG in the chat box, and hit the like button before we start, because once we start, then I will cover the full chapter in one go. Okay, so just before that, I request you all to like the video, because moment I do that, I will complete it. Okay. Okay, just hit the like button, because once we start, then we will directly complete the chapter. Today I will be covering around 5 to 6 chapters. Okay, so these are the chapters. Torts I will be covering. I will be covering your Arbitration Conciliation Act. I will be covering your Registration Act. I will be covering your IT Act today. Okay, and I will also look at covering your Specific Relief Evidence Act today only. Okay, that's it. Chalo, let's begin. Hi, so we'll be starting with your chapter called as Law of Torts. Now, what is a tort? A tort is a civil wrong. Wrongs could be classified in two kinds of wrong. One is a criminal wrong. Those wrongs are called as crimes, like your murder, extortion, etc. These are serious offenses, and for them, the state takes action. That means your police will take action, your government will take action. If there's terrorism, it's obviously a crime. The government of India will take action. But when we have personal wrongs are called as civil wrongs. Okay, let's say for example, a trespass, innocent trespass on your property, someone has come. Second, if someone has spoken bad about you, that also hurts your feeling. If there is a small little fight between you all where the injuries are not great, where it has not exceeded beyond 3 days, in such cases we can say it is a tort, it is a civil wrong. Now in civil wrong, you can go to the court for relief, okay. Now who will go? The party who has been affected, they will go for relief, and the relief that is given in torts is compensation. Okay, compensation is given as relief, compensation in terms of money, So you can always write this. What is a tort? A tort is a civil wrong for which compensation will be given in the form of money. Now just a few facts about it. Torts is a French equivalent of the English word wrong. So tort is a French equivalent which means wrong. Okay, in Latin language, tort is called as tortem. Okay, the person who does the wrong is called as a tortfeasor or a wrongdoer, and the act which he does is called as tortious act. So the person who does, like how we say the person who does the crime is called as criminal, here the person who does the tort, the civil wrong, is called as a tortfeasor. Okay, and as we say that the act is a crime in civil matters, in torts we will say it is a tortious act. Okay, and what is given? Compensation is given as relief. Okay, now tort is treated as a private wrong because I told you it is only affecting that party. The state will not take action. That party himself will have to go and take an action. Okay, let's say a simple example is your property. Someone is not paying rent on your property. So then what is it? Will state take action? State will not take action. It's a private wrong. You have to go to the court, take relief. It's a breach of their private duties. You can ask for compensation for not doing the work well. An individual has to approach the civil court for redressal. Sir, any other example of your consumer cases? You had something and it was not well, your computer came defective. State will not take action. It's not a serious thing. It's a private wrong. If I have bought a laptop which is not working well and is not giving me proper service, then I will obviously have to go to the consumer court and it will be treated as a civil case. And that act will be called as a tortious act. How we have the name of the act is a tort. The person who does the tort is a tortfeasor. Similarly, when we see criminal crime, when we see serious offenses for which imprisonment can be given, crime can be given, your state will take action, and it is treated as a public wrong. So crime is treated as a public wrong, affects the society as a whole. Okay, now let's see the three ingredients of torts. Now just before we go that, just understand one thing, that there is a difference between tort and breach of contract. Sir, what is a tort and a breach of contract? Something which is a pure breach of contract will go as per the Contract Act. It is a codified law and we have all the sections of Contract Act that will be applicable. Okay, so let's say if you and someone else has entered into a contract and the person has breached the contract, then you have to follow the Contract Act for it. Okay, the parties will decide the particular compensation amount, etc. Okay, that is there. Now when we see tort, a tort could be something which is not decided by the party. It is decided by the state or as a duty fixed by law. For example, not to trespass. So let's say if someone is doing a trespass. Sir, what do you mean by trespass? That means on someone's property you have entered without their permission. They can it is wrong, but it is a wrong as per tort, it is a civil wrong. So entering on someone's property is called as trespass. That is called as a civil wrong. This I'll tell who has told me. I have not entered into any contract. They say no, it is a duty fixed by law. Is there any sections like how we have for Contract Act? We have sections. For your criminal law, that is your BNS Act, we have sections. For tort, do we have sections? Answer is no. Tort is a uncodified law. That means there are no section numbers given. It is just a concept. Okay. Defamation is there, etc. Not to hit anybody. It's not written anywhere. Okay. It is a tort. Now, for a tort, for a civil wrong, 3 conditions are to be fulfilled. First one is it should be a wrongful act. Second, if there is a wrong, obviously there will be legal damage. So if someone has done something wrong, it will cause damage to someone and that person will then run to the court to get legal remedy. So there are 3 things or ingredients of tort. 3 ingredients of tort means what? Means whenever there is a civil wrong, 3 things will happen. Something wrong must have happened, it must have caused a damage to someone else, and the person will then get a legal remedy. Clear? Now, for your legal damages, there are 2 maxims. For your legal damage, like this second part which is there, tort, legal damage, there are 2 legal maxims, 2 maxims that are there, which we will try to understand. And they have asked multiple times in the exam, and we should know along with the case law. Okay, for both there is a case law we need to know. Okay, let's see. Okay, first, legal damage. It is not every damage that is a damage in the eyes of law. So, not legal damage means what? They have not said that every damage is covered. So, only legal damages are covered. Let's see what it means. That a damage in the eyes of law is only given compensation for. If, for example, I say this person has said something, it has hurt my feelings, it has caused me emotional stress, law will say we don't get, you can't go to the court for that. In eyes of law, some of your rights should have been violated. So from here, there are 2 maxims. What are those maxims? Damnem sine injuria and injuria sine damnem. Let's see. Okay. So the very first one is your damnem sine injuria. What does it mean? It means a damage without injury. So there is a real damage, there is a loss of money that has happened to you. Okay, damage always means a monetary loss, etc. Without legal injury. So with sine always means without. It means without. And injuria always means legal injury. Okay. So let's say there is a loss to you, but in the eyes of law, it is without a legal injury. It is not having a, legal injury. In eyes of law, it is not a wrong. So therefore, like an example of this is the Gloucester Grammar School case. There is a Gloucester Grammar School case where there is a competition. So in this school, the teachers left and started a competing school, because of which there was a damage, there is a loss to the original school. But in eyes of law, this is not a illegal injury. Competition, someone can start, your employees can leave and start their own business altogether and compete with you. That is absolutely fine. If you don't have any agreement, they can definitely go and compete with you. So can anyone take action because I have damage, but in the eyes of law there is no damage? So the answer is it is not actionable in court. So this is in Gloucester Grammar School case. So what happened here? Your competing school was started, caused damage, but in eyes of law it is not a legal injury. So no compensation is given. Next, if we go to see, is your sine injuria sine damnem. Injuria sine damnem means what? It's a legal injury without damage. Okay, so legal injury without damage means what? In reality, there is no damage. But in eyes of law, we can see a legal injury. So legal injury, injuria, that word is important. Legal injury is important. So the case law here was Ashby versus White. What case law we'll write? Ashby versus White. Where one was not allowed to go and vote by the election officer. So election officer did not allow Ashby to vote. Okay. So what happened is Ashby filed a case that listen, this is wrong. I was not allowed to vote. So she was of a particular political party and that political party won. Okay. So now the question came that her political party who she was going to vote only won. So in reality there is no damage to her. However, her right of voting was violated. So it is actionable in court. Why? Because there is a legal injury. In legal injury, what happened? There was a right to vote was violated. Therefore, a law allowed the case to be filed because legal injury was there, right to vote was violated, even if your party had won. So you have to write the case law Ashby versus White. Okay. Now we are coming to third important thing. Okay, which is three important things with respect to your liability. With respect to liability. Now there 110% if a question comes, one question will come from your only, which is about three types of liability under torts. So in tort there are three kinds of liability. Let's see. Okay, three types of liability. The first one is strict liability, second is called as absolute liability, and third one is called as vicarious liability. Okay, now let's understand what is strict liability. Now there are three kinds of liability. Once you understand this, the concept will go very easy. Okay, so strict liability. Now listen to the words, whatever I'm telling you, please write it down because my terminologies will be as per law. Okay, so strict liability is called as no fault liability. It is called as no fault liability. Okay, it says that if any person, so when we are doing strict liability, I'll tell you what it is. Okay, strict liability, when you are doing, first it is called as no fault liability. What we'll write, it is called as no fault liability. First. Second, we will write what it states. So you can write it with me. What does it state? Okay. So what is the rule? What is the rule of strict liability? It says that if any person gets any dangerous substance or thing or animal, gets it at its own peril. Gets it at its own peril. Peril means risk. That means if I get any dangerous substance or thing, I get it at my own risk. If this dangerous substance escapes, so then I will write that if it escapes, then you will be liable for compensation to the person who you have caused loss. So what is strict liability? That if you get any dangerous substance or thing, it is your responsibility, and if you cause loss to others, you have to pay. Simple. Strict liability means it is your liability, finish it off. Now in strict liability there are certain exceptions. Exceptions are there where you are not liable. In strict liability, we will see there are few exceptions where you are not liable. For example, act of God, if there is a heavy rains, etc. If there is a earthquake and there has caused you loss, then it is not liable. So first thing is we will see exceptions are there in strict liability. Now what happened is every time any person used to get a dangerous substance or thing, it used to escape, cause loss, they used to run in the exceptions and get the defense. So exceptions used to give defenses. If I fall in the exceptions, I don't have to give compensation. So then what happened is the government said that we need to revise this strict liability. We will have the same rule, but we will remove the exceptions. So what happens in absolute liability? It was held in MC Mehta versus Union of India. First there was the Bhopal gas tragedy. Then government said it was an earthquake. Then again it came oleum gas leak. Again they said it's an earthquake. Then we said MC Mehta filed a case and said that listen, if any person getting a dangerous substance or thing, there should not be any exception. They should be absolutely liable. So they say it's a very nice concept. So this is a Indian concept. This is a Indian concept, whereas this is a UK concept. Here the case law is Ryland versus Fletcher. Ryland versus Fletcher. This is the concept. Okay. Now, the third one, when we came vicarious liability, we'll see it's a for the agent, for the servant, the master is liable. Master-servant relationship. So here you are held liable for the fault of another. So your servant does mistake, the master will be held liable. One partner does mistake, the partner will be liable. Child does mistake, parents will be liable. So that is a vicarious liability. Now let's go into the depth and complete it. First is strict liability. What are we seeing? Strict liability. Strict liability, I told you, first you have to write the case law, Ryland versus Fletcher. So you will say that the rule of strict liability was propounded, founded, defined or brought in under the Ryland versus Fletcher rule. In that you give the rule, sir, what is the rule? That if any person brings any dangerous substance or thing and it escapes, then he will be liable to pay for the damages. He will be responsible. Simple concept. In this, what happened? Ryland erected a reservoir. He appointed an independent contractor. That listen, you will do the job, etc. The independent contractor was negligent. He did not fit certain wooden shafts. So while filling it, he did not fill it properly, because of it water from the reservoir bursted and it destroyed the house of the defendant, that is Fletcher. Fletcher's house was destroyed. So now what happened is, court said that listen, you brought, so he was saying that the independent contractor should be held liable. Court said no, it is a dangerous thing to set up a reservoir. You brought the dangerous thing, it escaped, it caused damage. Now you are responsible to pay to Fletcher. This was the simple little rule. Now after you've written the rule, then you write the facts of the case as I told you. Okay, Ryland erected a reservoir, it burst and it destroyed the house of the defendant. It was held that Ryland will be liable for compensation. Then after that, after writing the rule, writing the facts of the case, then you can write in Lead versus Leon, you will write the conditions. That for this rule to apply, for the Ryland versus Fletcher rule to apply, 4 conditions are there. 4 conditions are to be fulfilled. I have to remember the keyword bend. What keyword you will remember? Bend. B-E-N-D. That means it should be brought by the defendant, means who is accused here, he should have only got the particular dangerous substance. E is should escape. N is it, we'll come to that. D is it should be dangerous. So what has happened? The person has bought the dangerous substance. It is dangerous, he has brought it, it has escaped. And it is non-natural use of land. Non-natural use of land means unusual. Setting up a water tank is allowed. Getting a normal dog is fine. But if I get a lion, in Dubai they have lion, tigers as pets. So that is non-normal. So unusual. Non-natural use of land means what? Unusual use you have done. Then only this rule can be applied. So when can this rule be applied? When bend conditions are fulfilled. And then comes to the exceptions. Then we come to the exception that under these things, the person will not be held liable for under strict liability. Means if he has not, so he has done natural use of land, he has taken consent of the other side to set up the dangerous thing, it is allowed. Third party has come and destroyed it under the statutory authority. So maybe a public authority, public body has been set up. For example, reservoir built by the government will not come under strict liability because it is coming under rule of exceptions for the rule of strict liability. That statutory authority means a government, law, act, parliament has told to bring the dangerous substance. So then it will not be there. Act of God and escapes due to plaintiff's own default. So the guy who is complaining, it is his own fault. So what are the conditions? 1, 2, 3, 4, 5, 6. So let's see if we can remember the six exceptions. First, let's see, six exceptions we are trying to learn. First is, it is non-natural use of land. Consent was taken. Act of third party. These are the first three, and the other one is statutory liability. Plaintiff's own fault, and the third one is your act of God. Okay, so non-natural use of land, consent was taken, third party did wrong. Okay, it was own fault, plaintiff's own fault. S is for statutory authority, and A is for act of God. So these are 6 exceptions that are given. So if you fall under the exceptions, you are not liable to pay compensation. So again, and then we are done with the rule of strict liability. Okay, so now what is what strict liability, if it comes, what to write? It's a 8-mark answer. Strict liability. Okay, now strict liability, first we have to write the rule. What is the rule? Then you write the facts of the case. Then after the facts you will write the bend conditions. Okay, bend the conditions you will write under which strict liability applies, conditions, and then you will write the exceptions under the rule. Simple. Okay, and you're done with strict liability. Now, sir, can you teach absolute liability also? Now, in absolute liability, if I'm doing absolute liability, everything is same. Every single thing is same. Only one thing is you have to remove the exceptions. Exceptions are removed. So that is why it is called as no exceptions rule. That if you get any dangerous substance or thing and it escapes, the person will be absolutely held liable without any exceptions. So now what happens if I am setting a chemical plant? As per absolute liability, I cannot claim any defense only, that act of God, statutory liability. Everybody has to be careful. So therefore we'll write the rule that will be absolutely liable without any exceptions. Facts of the case. Now this was Ryland versus Fletcher. They are not Indians, right? It's a UK case. What happened is, first Bhopal gas tragedy happened. Then came the oleum gas leak. Every time they were bringing dangerous substance, it was escaping. They were saying act of God. They say no. Now if anyone is bringing any dangerous substance, they should take full responsibility. So therefore this absolute liability was decided in MC Mehta versus Union of India case. Okay, only thing, they removed the exceptions and applied. Okay, so let's see. What did they say? That first of all, it's only for dangerous substances, and only when you're dealing in, this applies only for enterprises dealing in hazardous or dangerous substances. Law said that you cannot every time claim a defense whenever a industry has caused damage to the public. Okay, so they said that we have departed from the rule of Ryland versus Fletcher and brought a new rule called as absolute liability or no exception rule. Okay, now it was held that anyone dealing in hazardous substances will be absolutely liable to protect the community and give compensation for loss caused, and they have to ensure the highest level of standards. Okay, they will be absolutely liable for compensation for such harm. Simple. Now we come to the third rule. The third was called as vicarious liability. Sir, what is vicarious liability? If I have to just learn from the words. Okay. Now vicarious liability is called as a no fault liability. What it is called? It is called as a no fault liability. That means I didn't do anything, but still I will be held liable. Or we can also call it as a held liable for fault of another. You are held liable for the fault of another, vicarious liability. So here you have to remember who will be held liable. If a servant has done something wrong, the master will be held liable. there are some rules why this has been there, because it is called as respondent superior. Then let the superior be held liable. The ability of the principal or the master will be much more. Okay, so these are some of the reasons why it is done, and the third reason is the work of the master is being conducted, so therefore the master should be held liable to pay the compensation. So here it says that the tortfeasor, the person who's done the wrong, is normally the tortfeasor is liable, but here the tortfeasor won't be held liable. His master will be held liable. A master is vicariously liable for the tort of his servant. So just write the word that the master will be held liable, vicariously liable for the fault of his servant. So if a servant is there, or who will be held liable? Master will be vicariously liable. If one partner has done a wrong, the other partner will be vicariously liable. If the child has done something wrong, the vicariously the parents will be held liable. Okay, who else is there? So if a contractor is appointed, we'll see with respect to that. Rest all is the same. Headings. Principal agent. So if the agent has done something wrong, the principal will be vicariously liable. Simple. It's called as QC. Simply means that he who acts through another is acting through himself. Means if I do an act to another, it is deemed it is my act. So if I appoint an agent and the agent does something wrong, it is deemed to be my act. That is why it will be held liable. Okay. Now only I will be held liable if it is done in the ordinary course of business and the agent has not exceeded his authority. If the agent has exceeded the authority, let's say for example my agent went to sell something and then he ended up with a fight and he murdered someone, I will not be held liable because I did not tell him to do all that. Only which is coming in the ordinary course of business, which is naturally which is there, that will be held liable. Next, partners. Now what are partners? Now first thing is, in partners in Hamlin versus Houston. So one partner, always partners are deemed to be principal and agents of each other. So one of the two partners bribed the plaintiff's clerk. So one partner bribed to the clerk, induced him to divulge certain secrets. It was held that both the partners were held liable for the tort committed by only one of them. So this was there. Both were held liable. Because when you have a partnership firm, you are held equally liable as your other partners. Master servant is also covered. Now remember, for employer and independent contractor. For employer and independent contractor, there is a simple rule. Pay attention. Okay. Now this is important. Now when I appoint a contractor, normally I will be held responsible because he is the agent, I am the principal. But when I appoint an independent contractor, now you can take a screenshot of this. Independent contractor. Sir, what do you mean by the term independent? Means he has his own employees, he is working independently, he is not working under my instructions. So principal and not controlling the day-to-day working of the contractor. He says, okay, fine, you make it like Mukesh Ambani. He appoints independent contractors. He doesn't come to see the day-to-day. So control is not there. Independent contractor has his own employees and he has his own instructions to his employees. Now, if the independent contractor is appointed for dangerous substances, then automatically Ryland versus Fletcher rule will apply and the principal will be held liable, not the independent contractor. As we saw in rule of strict liability, that any dangerous substance who brought it will be held liable. You cannot tell that the independent contractor will be held liable. That was held there. Normal circumstances, when I don't get any dangerous substance etc., then obviously the independent contractor will be liable and not the principal, because only when dangerous substance is coming, principal will be held liable. Okay, in cases of independent contractors, normally is different, because independent contractor, the principal doesn't have control, okay, for the working. So we say, okay, fine, he is independent from the name itself, he does his own job, then how I can be held liable? So in normal circumstances, it's fine, he is doing his own job with his own bill, with his own everything, so then he will not be held liable. Now principal will not be held liable in normal cases. It is the independent contractor who will be held liable. Common sense, na? If let's say your building is appointed to make a lift, it's not a dangerous thing, and something goes wrong, the independent contractor will be held liable. Simple. Now we come to some torts, very important, okay, very important with respect to freedom, personal freedom, etc. Let's understand, okay. The first one that we are doing is called as battery. Sir, what do you mean by battery? Okay, now pay attention. Now we are seeing wrongs on person's freedom, and means they're talking from a person, we beat him up, we lock him up, so all his personal freedom, his safety, etc. is involved. We give him a nervous shock, so all these cases will be seen. These are all considered to be a tort. These are all considered to be a tort. So for example, if I come and I lock a person in the room that he cannot go anywhere out, there is no opening only. So it is amounting that you have done a tort. Okay. Law has said that this you cannot do. Okay. For which you will have to pay compensation. So let's see the different kinds of torts. The first one is called as battery. Sir, what do you mean by the term battery? So battery means the use of force without lawful justification. So what does battery means? That you have used force. So actual physical contact is there. Even a small amount of physical contact, such as touching a person, also will amount to battery. So it means the use of force without lawful justification. It is any direct application of force without the consent amounts to battery. So there is use of force without lawful justification. Okay. Second, assault. In assault is exactly the opposite, where there is no use of force is there. Now understand what is assault. So there is without use of force. You've given a threat. You've given a apprehension. That force will be used. That force, that means battery, will be used, will be done, or committed. Will be committed. Will be committed means what? Let's take an example that where one party, or we can say the one is the plaintiff who filed the case. That means that on the defendant must have hit him. So where the defendant has created an apprehension in the mind of the plaintiff that battery will be committed. For example, I say I'll beat you up so badly. So what you have done? You made a statement. You created an apprehension, a belief, anticipation that force will be used. Okay. Now your actual force is not used. It is a potential. So normally before battery, assault comes. So assault comes first, where you give some words, some threats, etc. And then you do your battery. Pointing a loaded gun, you've not used force, but is also coming under assault. Then comes bodily harm. Sir, what do you mean by bodily harm? Bodily harm means a statement that causes physical harm. What does a bodily harm mean? You made a statement which causes a physical harm. For example, if I tell someone comes to me and says this is good to drink and I know it is acid, I say yeah, you can drink. My statement has caused physical harm. A blind man is walking, he takes my direction, I give him wrong direction and he falls and he gets hurt. It is called as bodily harm. So your statement has caused someone physical injuries. That is called as bodily harm. Now the next one is called as false imprisonment. False imprisonment is if you lock someone in a room. You lock someone in a room, okay? Then what happens? It's called as false imprisonment. Now, how do you define false imprisonment? Two cases are there. So for false imprisonment, there are two things. There is a total restraint. There is a total restraint means a complete blocking of a person without lawful justification. Without lawful justification. So total restraint means what? In no direction the person can move. So it is restraining a person's ability to move. So locking a person, it is a serious violation of a person's right to freedom of liberty, leaving, etc. Then comes to the next thing, which is called as malicious prosecution. In malicious prosecution, what happens? someone has filed a fake case on you. You won the case. Now the innocent person will file a case. On the particular defendant. Will file a case on the defendant, saying that you had filed a malicious case against me, and now give me compensation. So what happens is, here the person, there must be a previous case, and the defendant in that case was innocent. He won the case. Now he will come and he'll file a case that in the previous suit has gone in my favor. It has caused loss of reputation just by of the case, so I'm filing this case. So when a person files a malicious case against an innocent person, so someone has filed a malicious fake case against an innocent person, and the innocent person suffers damages, then that innocent person has a right that if anyone has filed a fake case on you, you have a right to file a case on them and recover compensation. Okay, so you will institute a case of malicious prosecution instigating that the earlier suit was filed. It was there has been a prosecution. It didn't have any lawful justification. It acted maliciously, that is improper motive. I suffered loss of damages, job, etc., and it terminated in my favor. So I'm filing a case saying that it terminated in my favor. I suffered damages. Please give me compensation because a fake case was filed against me without lawful justification. Simple. Then we come to the next thing called as nervous shock. Sir, what do you mean by the term nervous shock? So nervous shock is not a physical injury. So first you will write that a nervous shock, it provides relief when a person may get a physical injury not by impact. Okay, like a blow or any bullet or any sword, etc., but merely by nervous shock through what they have seen or heard. So when you play a prank by telling someone that this person is killed in an accident, the person will get a nervous shock, so they get an injury, they might be hospitalized, etc. So injury is there not by impact but by words. So in such cases, you have created a shock in the mind of the person through an emotional outburst such as this emotional disturbance, fear, sorrow, etc. So the person who has undergone nervous shock can apply for compensation. The next thing is called as defamation. Okay, now what is defamation? So defamation is basically, understand, it's a statement that it's a false statement. So you would write defamation is a false statement. It's a false statement made against a person which lowers the person in reputation, lowers the reputation of a person in society. So that person, maybe it could be of two kinds. It is called as libel or slander. Slander is merely by words, and this is any permanent source. Okay, there is some permanent form, like maybe any videos, any kind of book, novel, etc. Okay, which is there. So which is more serious? Obviously libel is more serious because the defamation is present in a permanent form like a YouTube video. So therefore you can apply for compensation. So a defamation is an attack on a person's reputation. It is a publication of a statement that lowers a person's reputation in society. There could be two kinds. One is libel. Libel is any permanent form like your words, caricatures, newspaper article, movie, cinematographic thing, any videos. And slander is in a transient form. Transient means temporary form. So maybe I have just said the word and done. I have just orally said something. So that is not counted. Now this defamation is now covered under section 353 or of the Act, of the BNS Act. 353 and 354. Okay, you can write of the BNS Act. Now remedies in tort. So if a tort has been committed, what remedies do you have? So what do you mean by the term tort? So tort means a civil wrong. So if a civil wrong has been done, then what? So what remedies you can ask? So the first one is you can ask for damages, which is the most common, that is compensation. Second, you can ask for injunction. Injunction means telling the other side to stop doing it in future. And third one is restitution of the property. So imagine if someone has taken your property, they will ask to restitute the property, restore. They will ask for restoring the property back. So these are the normal remedies that the court will give. These are called as judicial remedies. So remedies could be judicial remedies which the court will give, and the other one is called as non-judicial remedies with the or extrajudicial, which is outside the court that you can get. So what remedy I can get outside the court? The very first one is called as self-defense. If someone is committing battery, obviously you will not keep quiet, you will defend your person. So with use of reasonable force to protect oneself. So it is lawful for a person to use reasonable force to protect himself. Second, if someone is trespassing on your land, what will you do? You will obviously stop the person from trespass. Third, if someone has wrongfully entered in your property, you will re-enter and retake possession of the land. Recaption of the good, that is, if someone has taken away your goods, you have a right to take possession of the goods back. Abatement of nuisance. So you can, abatement means to terminate. So you can terminate through your own means without with reasonable force. Okay. Now distress, damage, feasant. This means with respect to cattle, animals, etc. in villages, when animals are there, if any animal has come and has damaged your farm, what remedy you have? You can keep that cattle till compensation is given by the owner of that animal. So any occupier may lawfully seize any cattle. So you are keeping the cattle with you, okay, because that cattle has unlawfully entered in your land and has caused damage, and now till you don't get compensation, you will not release the thing. So this is one of the remedies that you will get. Okay. Now we are seeing vicarious liability of the state. Sir, what do you mean by vicarious liability of the state? My question to you is, when all these bus drivers are there, BEST and all those, government, they cause an accident, can you claim compensation from the government? Because obviously that driver will not be able to pay compensation. Can you ask compensation from the state? Answer is yes. So there is some rules, pay attention to it, that vicarious liability against the state is divided in two heads. Okay, vicarious liability is divided in two heads. So we are seeing vicarious liability of state. Okay, that when I say state means what? I'm meaning government. There are two things. One is if the government is performing sovereign functions, and the other one is government is performing non-sovereign functions. So non-sovereign functions. Okay, let's see what's the rule. So sovereign functions means only the government can perform. Only government can perform. Okay, perform, nobody else. So for example, defense. For example, defense. Example about judiciary, the government, the court systems, etc. So if there is anything wrong, we say the process is very slow. In court it goes. So obviously you cannot file a case, on government for compensation. For example, if there has been a war on India and it has destroyed, the enemy has destroyed some of the property of the person, can he file a case and recover from the government, saying that the government could not give him sufficient defense, could not protect him, so they want the money? So the answer is no. The government is performing sovereign, supreme functions. For that, state cannot be held vicariously liable. So you'll write here that the state cannot be held vicariously liable for sovereign functions. But where the government is not performing sovereign functions, so what does it mean? For example, government is giving postal services. Government and private sector both give those functions. Then when a private company cannot give you services, you can file a case. Similarly, here also you can file a case. So your government can be held liable. Government can be vicariously liable. For example, we have speed post which is given by private sector, and we also have the government post. If speed post, any FedEx or DTC or any other courier agency, professional couriers, they have not been able to deliver or they have lost your courier, you will be file a case on them for compensation. Similarly, the government, you can also file a case. Why? Because they are competing with private sector and it is a non-sovereign function. So then it is allowed. Okay, now there was a case in state of Rajasthan versus Vidyavati. I'll tell when we come to it. So let's see. Okay. So when a government is liable in tort came as a question, so it has to be determined whether it is sovereign or non-sovereign functions. Okay. In sovereign functions, government can claim immunity, can claim protection, and they will not be held liable. However, in non-sovereign functions, where the government is acting through as a commercial business, like government has so many stake in so many companies, etc., they can be held liable. Okay, so in ocean navigation versus state of India, the question before the Supreme Court was whether the state is liable for compensation for the this, and it was held that yes, they will be held liable for the act of their employees. The state will be held liable for the act of their employees. And a very interesting case which they've also asked in the exam many times, that in state of Rajasthan versus Vidyavati, the driver of a jeep of the Rajasthan government caused accident. The Rajasthan government had to pay compensation as it was held vicariously liable for the wrong or negligence done by the driver. Similarly, in Kasturi Lal versus state of UP, same thing, that the government is not held liable where they are performing sovereign functions. Then damages. So government can be held liable. Now they are just seeing some cases that government cannot be asked when they are giving sovereign functions to give compensation. However, if the government feels they want to give, they can give. So there was a Rudil versus state of Bihar. Okay. The court, the petitioner was detained illegally in a prison for over 14 years. So 14 years government had done. Now this is somewhere like a sovereign functions. Government said, okay, fine. The court awarded rupees 30,000 compensation to the petitioner. So they can claim, but if they want, they can give compensation also. And that is it. We have completed the entire chapter. It's a 8 to 10 mark chapter. That is it. We are done. Okay. So let me know in the chat box if this chapter is clear with you. Write clear in the chat box. Everyone write clear in the chat box so I can quickly go to the next chapter and complete it. Okay, write clear in the chat box so we can complete it quickly. Everyone in the chat box, is it clear? Yes or no? So that I can quickly start, quickly. Waiting for your confirmations. Write clear in the chat box so I know, so we can go to the next chapter and knock it off. Sona, great. What about the others? Arun, Sneha, great. Super clear. Thank you so much. Okay, so this chapter is done. I've covered everything. Not a single question can come outside from what we have done. Okay. Great. Chalo, now we start with the next chapter. Okay, now let me see. Which chapter? So we've covered this. So let me take this also. So whichever we are done, we will click. So many are asking, yes, we are almost covering the full syllabus. So this is also done. Law of crime also I have done. Full my marathon is there. You can see all the crime, and last time only I had done the BNS and BNSS Act also I have completed. BNS and BNSS Act. If you want, you will get the lecture in the dream batch also. Full chapter I have completed in depth. You can do that. Now, one chapter is there which we'll do in the end of the day, which is your Evidence Act also we'll complete it. Now let me see which we can complete. So I'll just take between your Registration Act and Information Technology Act we will start. We'll just take a 10-minute break and we start at 7 p.m. Okay. So we start around 7 p.m. and we complete your one of the two chapters, and both the chapters will come and complete. Okay. So that is it. We'll be back. Till then, you can revise some chapters and keep. So I'll see you all again and I'll complete this chapter. Registration Act, your Registration Act or your Information Act or Specific Relief Act. So these chapters I'm targeting. Okay, after break. Okay. Okay. Hi. So we'll be starting with your lesson called as Information Technology Act, your lesson number 15. Now, before I start, can I have in the chat box I'm audible, visible, so I can quickly start and complete it? Okay. So we will be starting with your Information Technology Act 2000 and completing it. Just waiting for you all. So it is around again a 8 marker chapter that we will be starting and completing it. In the chat box quickly, so we can start and complete. Okay, Sona, thank you so much. What about others? Okay, so let's begin. Siddharth, great. Let's start. So we'll be starting with your chapter called as Information Technology Act 2000. I'll be covering everything including past exam questions, the amendments, everything which is there. Let's start. Okay, and the marking also I will give you what is important from exam point of view. Only those things I will be touching upon and completing it. Okay, so you can mark it along with me and you will be done with the chapter. Okay, great. Let's start. Okay. Hi, so we start with your lesson called as Information Technology Act 2000. Now, what does this act really contain? So nowadays, information is contained in your technology such as your mobile phone, laptops, etc. And nowadays, whatever you're seeing is through these digital assets which are containing a lot of information. This act covers them all. Now, obviously, it was in the year 2000, so there was something that happened before the year 2000. It starts from your 30th January 1997. Now, United Nations actually made a model law on e-commerce, and they told all the other countries that you also make a model law, you also make a law based on this, because there was a massive advancement of technology from 1997 onwards, and that time only United Nations had forethought that technology, internet will become a really big thing. So your United Nations General Assembly, they had a resolution on 30th January 1997 where they adopted something called as a model law on the e-commerce. Okay, and it was adopted by the United Nations Commission, UNICITRAL, basically United Nations model law. So UNICITRAL had adopted the model law on e-commerce. Now, based on the UNICITRAL model law, the India passed a law called as Information Technology Act 2000, which was later amended in 2008. All the important amendments had also come in 2008, which spoke about cyber terrorism, etc., which is now the complete amendments are there. Now let's look at the object of the act. What are we looking at? The object of this act. What is the object of the act? Now if I go to think that what does Information Technology Act actually talk about? So it says that it gives recognition to digital contracts. It gives legal recognition to contracts, to digital payments, to digital transfers, to digital everything, digital publications, etc. Okay, so let's see, from as a company secretary point of view, we do a lot of e-filings from the government of India. So now government of India has said that you can do e-filings. Instead, all the filings with the government agencies with your MCA is done through e-forms. So what does this act do? It give permission to all the other acts that now you can accept digital filing. Okay, it facilitates, permits, allows electronic filing. It gives recognition. What does it do? It gives recognition to digital online transactions. Simple. And because of that, it brought in a lot of amendments, like all the other laws had to get amended due to this Information Technology Act, because now the RBI Act, your Evidence Act, your RB, all the other laws were amended to bring IT Act to allow the facilitate digital transactions. Simple. So what does it mean? After the IT Act, now we know that digital payments are allowed. So Companies Act was amended that they said digital payment can also be done. Okay. Now, and then we had something in India called as MCA 2000, where all the forms were told now file online only. Now let's see. However, we know that all documents can now be, which were required in physical forms, are now allowed in digital form also. However, some documents cannot be digital, it has to be physical mode only. Your first schedule contains certain documents for which IT Act does not apply. That means electronic means are not allowed for its recognition, and physical documents are only allowed. So which are those documents? So schedule 1s are containing a negative list that IT Act does not permit these particular transactions or documents, and they have to be mandatorily physical mode. Like your Negotiable Instrument Act, when you see a check, okay, or Negotiable Instrument Act, all those that are covered has to be like money, physical form, etc., which is there. So they will tell you certain negotiable instruments will have to be in physical mode only. Power of attorney cannot be online, it has to be in physical mode. Or trust deed, etc., has to be in physical mode. Will be in physical mode. And whenever you're selling property, etc., the document sale deed will be in physical mode. So there are 5 transactions in total which the IT Act will not apply. Okay, so nothing what is stated in IT Act shall apply to documents specified in first schedule. So it doesn't matter what is stated, IT Act will not apply to the following things. Simple. Next, so 5 types of transactions have to be physical only, electronic this is not allowed. Now definition. Now certain definitions are there, we will see, very simple. Okay, we don't have to know all the definitions. Now if I go to see some of the definitions which are there, I'm just seeing this. How do they define computer? They say a computer is a data processing device, high speed data processing device, where you have, what does it do? It does IPOs. What does it do? Input, process, output, storage. So a computer is a high speed electronic device where you input details, it immediately gives output, and it is even a storage device. So just general, not that important. Now this definition you can note down. When we come to it, we'll do what is digital signature. Okay, section 21P, very important. Okay, and something about a key pair, this also you can note down that it is a, what it is, we'll see, a private key will be mentioned and a public key will be mentioned. I'll tell you when we are doing section 3, digital signatures, how they are done. There is a certain, how it is done practically, I will tell you. So there is a pair, key pair, which we will see, a private and public key. Private key you sign, public key you verify. So with the private key you do a signature, and with public key you verify. This we will do when we do section number 3. Okay, let's see. Now we start. Okay, now let's understand first digital signature. When I say, and electronic signatures, are they the same? Digital signature includes all the forms of digital and electronic signature. So let me tell you that the 2008 amendment that had come, I'll explain you the concept, pay attention, that in 2008 an amendment has come where they brought in a concept called as digital signature within the concept of electronic signature. So digital signature is here, a wider concept is called as electronic signatures. So in the 2008 amendment they brought 2 definitions. Electronic signatures is a wider term. It covers all the methods of signing. It covers all methods of electronic signatures. It covers all the methods of electronic signatures. Whereas when I talk about digital signatures, they are talking about a digital signature certificate where there is a private key, where there is a public key, okay, and it is based on the asymmetric crypto system. So there is a specific technology. This they are talking of a specific technology. Okay. Now this technology is used by Ministry of Corporate Affairs, etc. And nowadays when we get a DSC, digital signature certificate, we get a certain locket, which way we get the private key, we put it, anyone can verify that document also through the public key. So digital signature is a very specific, it talks about this token. So this token, so section 21P talks about, just remember the word DSC, digital signature certificate. So it is this. So this is a digital signature token. So it tells that you use the methods. It is authentication of electronic record by way of a method provided in section 3. So in section 3, when you will go, you will see they will mention the word private key, which is a nothing but your password that you get. You install that, you will be able to sign. Public key will help you verify. This all is based on the asymmetric crypto system. Just these keywords you write, when we do it, you'll come to know. Asymmetric crypto system where there is a hash function too. So a hash function encrypts your data. It encrypts your data. It converts all your data into a non-readable form of data. So all these keywords you need to write for digital signature. Section 21P. So what is it? If today I want to sign a company law form, what do? I installed a DSC. I use my private key to sign. Anyone in the public can verify through the public key. This entire in the backend is working on an asymmetric crypto system, which talks about a key pair. It talks about a key pair, private and public key, one to sign, one to verify. And when you sign, it converts the data into a non-readable form of data, okay, for anyone else. So it prevents hacking, prevents any kind of during transmission it goes through a secure method that is done through a hash function. That's all. Okay. Now, and electronic signatures, as I told you, is a wider term. In section 21TA, what does it say? It is authentication of any electronic record. So all this we are signing, right? So we don't say the word signing, we say the word authentication. So I'm authenticating an electronic document through any means specified under Schedule 2 and includes digital signature. So electronic message is a wider term. So nowadays you have OTP signing, you can verify through your Aadhaar card. So that also signing is there. It is available. So there are certain portals where you can go ahead, put your phone, mobile number, Aadhaar card, you will get a OTP and the document will be signed. Now this is a newer form of signings that have come. Okay. So that is also there, which has been recognized by Schedule 2. When you go for your driving license also, they don't have digital signature certificate. They take basically your on the notepad they do it. So that all is electronic sign. It is any means of authentication of electronic record which ensures that you have followed all the procedures given under Schedule 2. Schedule 2 gives you certain certain methods to ensure that it is secure. Now, as we have done, now what did we do? We did digital signature certificate already. Sir, what is digital signature certificate? In words, if I say digital signature is a method of authenticating electronic records. So it is a method. I told you all to learn certain words also. First you write it down. It is a method to authenticate electronic records. It's very, very important. It is a method to authenticate, that means sign. Okay, sign electronic record. Okay, now I told you in DSC you are using, they are telling you the technology. So you are using the asymmetric crypto system, which has two key pairs, which has a key pair, a private key to sign and a public key to verify. It has a private key and a public key, and once you sign, it converts it into it encrypts the data with the help of hash function. Okay, so what is a hash function? Also, it converts the data into a manner which is non with the ultimate number. You will not be able to come back to the original document, means with the hash result. So when I use a hash function, it converts your data, it encrypts your data, okay, into a non-readable, means for the humans it is not readable. It converts the data into, that data is called as hash result. So what is a hash result? Hash result is encrypted, or I could say another word is secure. So with the hash result, ultimately after encryption, you cannot come back to the original data. That is what the hash function does. Okay, so section 3a defines what is electronic signature. Electronic signature, remember, is technologically neutral. Technologically neutral means what? They are not telling you use a schematic crypto system, key pair, etc. That is told under section 3, digital signature, DSC. In electronic signature, it is saying you use any method. You use any method which is considered reliable and may be specified in schedule 2. So in schedule 2, they talk about Aadhaar signing. Aadhaar signing has been recognized in schedule 2. Okay. So when you go to schedule 2, there are two types of e-authentication given in schedule 2. Schedule 1 was what? Certain documents, 5 types of documents on which Information Technology Act doesn't apply. Will, property documents, negotiable instruments, okay, power of attorney. Okay, so they have given those documents on which it doesn't apply. Schedule 2 talks about methods. I told you Aadhaar based signing is covered and any other signing which is considered reliable. That is it. Okay. Now when I say, sir, reliable means what? When I say that an electronic signature or a method of authentication, a method of signing is considered reliable if, so when you will consider reliable, I'm just thinking how I can consider that this method of signing is reliable. So if I say that any alteration can be detected, okay, with respect to the signature, any alteration with respect to information can be detected, okay, any particular signing I can locate it that yes, the originator has only signed, the signatory has only signed. So the signature creation data, okay, and authentication are within the used linked to the signatory and no other person. Means what? When I can identify that basically the signature creation data, for example, the DSC token which is there, it's a signature creation tool, na? That can be linked to you. So I will come to know. So nowadays I have a DSC. So in that it is mentioned Zubair Jahangir, Samina Jahangir, you know. So all those are mentioned. So the creation data, you can link it to the signatory and no other person. So your posting from your Instagram account, it means that you have posted it. So it is linked to you and nobody else. So we know that the signature creation method is linking it to that signatory and no other person. Simple. And at the time of signing, it is under his control, that also can be identified through technology. Sir, how we can identify? Nowadays what happens with your IP address, we can identify that whether you have signed it or no. Okay, so we can signature creation data at the time of signing was under the control of the signatory. Simple little points that they have given. Any other condition. So we will then consider that the data is reliable. Now we come to this other thing which we can go faster because very general points they have given you. Pay attention. That we are doing section number 4. So section 3 we did. I told you, digital signature. We have done achromatic system, hash function, key pair. All these keywords you have to write and build. Now section 4 onwards is very simple. That electronic governance, legal recognition of electronic record. Now pay attention. what does IT Act actually do? IT Act is not creating anything new. They are only facilitating, they are only permitting, they are only authorizing, they are only entrusting that whatever is in physical mode can be in digital mode. Okay, so whatever you do in physical mode can be done in electronic mode. Okay, for example, any document, any payment, any certification, all can be issued in electronic form. That's it. See, the act grants recognition to electronic records. Okay, information can be in writing, typewritten, this, and it could be in electronic form. So what they have said, this act says that information, what does it say? Defined what is information. So information can be in any method. We are most concerned with it can be in electronic form. Done. Private transaction. Now we see section number 4 is done. Private transaction. Thus, what does private transaction? Section 4 of the IT Act practically equates electronic record with manual or typewritten form. Means they have brought everything in the same line, whether it is typewritten, written, even electronic is covered. Now we saw section number 3, section number 4 giving recognition to electronic records. They have told that information can be even in electronic is what they have written. So what is section number here? What are they saying here? Essentially that information can be even in electronic form. Okay, this is your section number 4. Section 3 I want you to remember, okay, which is about digital signature. So it is very important, and all those keywords which I have told you have to write. Now when we see section number 5, okay, so what is section 5 talking about? Very simple. Okay, so all this is not important. I mean, just a simple reading and it is enough. It has given recognition of electronic signature. The earlier section 4 says information can be electronic. Now they are saying even signature can be electronic. So how nowadays if you open a bank account, you've opened gone for driving license, all your signatures are electronic, right? So that is also allowed. So electronic signatures have been legally recognized under section 5. What does it say? That where any law requires information or any other matter shall be authenticated by affixing signature. So where any act is saying that you have to sign, then that requirement is deemed to be satisfied if such information is authenticated by electronic means. So if any act is saying that you have to sign, that requirement of signing is sufficient if you sign it through electronic means. Done. Okay. Now we are done with section number 5 also. Now we are doing section number 6. What is important I will tell you. Section number 3 is important. Section 6, use of electronic records and signatures in government and its agencies. Now we are saying that even to government they have allowed. For example, if I make the payment on MCA website, MCA issues the receipt in electronic form. So what government is also issuing, if today I apply for, let's say, a GST certificate, I will get it in electronic form. If we are also applying for any license, that also government can also issue. So the section has been given that even government and government agencies can use. So where law provides for any filing, any license issue, okay, or payment, such requirement shall be deemed to have been satisfied. Such requirement shall be deemed to have been satisfied if such filing, issue or receipt or payment is affected by electronic means. So very simple act, very basic act. It is facilitating online transactions, online signatures for everyone, including government. Beautiful, sir. Let's move ahead. Okay. Now they have added one section called as delivery of services by service provider. Delivery of service by service provider. So what does it mean? That section 6A says that the government may, for efficient delivery of services to the public through the electronic means, authorize, so the government may authorize any service provider to set up and maintain and upgrade the computer facilities. Any service provider to upgrade the this provide and okay. So what does it say? Let's take an example. So what are they saying? That let's say there is a service provider. Let's say we are using technology service. We are using which mobile service service provider are you using? Service provider, internet service providers are you using? Please tell me. Can you mention in the chat box which internet service provider you are using? So possibly you might be using Jio, you might be using Airtel, you might be using Vodafone. So you will be using these services. Okay. So what they are saying, that government of India nowadays, due to technology, due to hacking, due to advancement of technology, government might tell that any service provider that you please upgrade your computer facilities so that you can fulfill the requirement under the act. So they can tell you to upgrade, set up, maintain, anything. This was your section 6A. Now we are seeing your section number 7. So what is section 7? It says that permission to retain the information in electronic record. Okay. Now wherever the government tells you to retain, okay, in any act, if you are told to that you shall retain, you can retain the information in electronic records. For example, minutes of meeting. Now all of you all are company secretaries. We have told that we have to maintain minutes book. If any document is, if any law is saying that you should have a document should be created, if you retain it in electronic form, it is allowed. So it also gives you permission to maintain information in electronic records. Next example, books of accounts. They teach you accounts in all book, paper, and always you go in the exam and write. But in reality, nobody is using book and pen in real life to make accounts. The companies have transactions of crores. So now they have said that all those accounting, etc., can be maintained in electronic form. So you can maintain and retain and preserve information in electronic form. Even audit documents and audit document retention can be in electronic form. So where any law says that there is a provision for audit of documents. Now imagine an auditor is appointed, he has been told that you should audit documents. He will say, I have to audit physical documents or online documents. So company will say that, listen, nowadays due to technology, we have everything in our tally software. So the auditor will also come and audit not physical electronic records. So the records, etc., shall also be applicable to audit documents which are maintained in electronic form. So the auditor has to record and audit and check documents which are in electronic form. So we are done with section 7A also. I hope you are writing down section wise. If you are not, start writing. All we are doing section wise. Okay, nothing can come outside. Next is subordinate legislation. Sir, what do you mean by subordinate legislation? Now pay attention. Now, when an authority publishes a law, subordinate authority like your GST council, which is subordinate to the central government. So central government, parliament has made the law. They have now given all the powers, the act has given the powers to the GST council to make all amendments, etc. The GST council is a delegated authority. The powers of the making the law has been delegated to GST council. So GST council, when they make a law, that law is called as delegated legislation. So when the delegated authority makes a law, GST council makes a law, that will be called as delegated legislation. Now pay attention what they are saying. Now when they make a law, they will publish it. They will publish it in the official gazette, or which is of paper, newspapers, or they can do it in electronic means. So even authorities can publish acts. Now let's say the new act is coming, okay, let's say the direct tax code is coming. Now if the direct tax code is coming and publication is made, one in official gazette and the second is in electronic gazette. Official gazette is a physical paper, this is physical form, and electronic is online form. So when it is considered that if two different dates are there, subordinate, if the authority has published in the official gazette in 2020 and the second one they have done in electronic gazette in 2019, which date will be taken? So whichever is earlier. What is the line? That the date of its first publication in either of the two will be taken into consideration. So this will be deemed date of publication. Clear? So if physical is there and online is there, so whichever earlier date of publication will be deemed that the act has been passed, published, etc. Okay, so this was a section number 8. Now when we go to see section number 9, section 9 says that just because the act has given you power and all the electronic recognition is there, that does not mean that any citizen can go and take electronic only, I will not give physical. So they are saying that listen, we are recognizing, facilitating, empowering electronic documents, but we are not taking away the right of the government to demand physical copies. So we are nothing giving any right to any person to insist that any authority shall accept electronic document. Means in this entire act, can I force the government to accept electronic records? Answer is no. Government may choose and demand physical copies. Okay. Then we see section number 10A. What are we seeing? Section 10A. What does section 10A talk about? Validity of contracts formed through electronic means. So if you know the name here, this is sufficient. Now section 10A we are doing. Pay attention. What are we doing? We are doing section 10A. And it is talking about validity of contracts if it is done through electronic means. So simple line what they have said, that if a offer and acceptance, and acceptance is done through electronic means, it is allowed, it is permitted. So they have written in the negative sense that no person can say that just because our offer and acceptance is through electronic means it is not allowed. Okay, so it is not deemed to be unenforceable. What is the line that such act shall not be deemed to be unenforceable on the ground that it is made on electronic record. Means no person can say that it is not enforceable simply because it is made in electronic record. So in simple lines, if I have to say section 10 in simple lines, that a contract cannot be denied enforceability just because it was exercised electronically. This is your section number 10, which talks about Contract Act. It talks about contract. So perfect, easy, very, very simple. Let's move ahead. Now, attribution of and dispatch of electronic records. Now, when I say attribution means what? If imagine from your phone I have received a message. From your phone I received a message. It will be attributed that you have sent it. So always any electronic record will be attributed to its originator, from whose device or computer resource it has reached. So first thing is, attribution will always be to the originator, So we will say that if a message is coming, an email has come from your account, we'll attribute it to you. So any electronic record will be attributed to its originator. Okay. Now broadly, the originator is the person who at whose instance it was sent in the following cases. Means if it was sent by the originator himself, he will be covered. If it was sent on the originator, still on behalf of the originator, still it will be counted. Or if it was sent by a system which is programmed to send it on behalf of the originator. So automatic messages has reached. So every time we will originate it, we will attribute it to the originator. So whether it was sent by himself whether it has been sent. Attribute means what? We will assume that it has been sent by the originator if it was sent by himself or agent or through a automation or through automation. Nowadays what happens, email automation is there, WhatsApp automation is there, automatic messages goes with my number, so then I'll be held responsible. Okay, now regarding acknowledgement of receipt of electronic record. Now when it will be deemed that it has been received by the other side? So where there is no agreement for acknowledgement in a particular form. So if there is no mentioning that this is a form of acknowledgement and this is a form of way of giving the message or receiving the message, if that is not given, then it is deemed that any communication by the addressee, automated or otherwise. Imagine if I have sent an automatically WhatsApp message comes that I have received the message, thank you so much for contacting so and so. Nowadays we have these automated WhatsApp messages also. When you send to someone, the business automatically responds. So it will be deemed that the receipt of the electronic message has been done when there has been from the recipient, that is the addressee, some message comes, or on conduct of the addressee which is sufficient to indicate that the originator has sent the message and that he is received. So any conduct means what? If imagine I have sent you a message and then of whatever message I've done, and on pursuant to that you've done some action. So on basis of your conduct I can make out that you received the message. So the receipt of electronic message is when communication has been made by the receiver or by his conduct. Simple. Time and place of dispatch. Now again this is also very simple. We've done section 12 till now. We've done section 12. All in order we are doing. Now we're doing section number 13. What we're doing? Section number 13. Time and place of dispatch. Very, very simple. If you know your contract act, this will get over. If you know your contract act, this part will get automatically over, because that is full same concept. That if I say that when, okay, so let's say the date of offer and date of acceptance are crucial to determine whether a contract has come into existence. So we need to know that when the offer has been given and when the acceptance has been done, because on that time the contract gets completed, because we know that offer plus acceptance, okay, is equal to a contract if it is enforceable by law, agreement enforceable by law. So we have to see the time. So the dispatch of an electronic record occurs when it goes outside the control of the originator. So when it goes outside the control of the originator. So obviously moment I have sent you a message, it has gone outside my control. I can say that the dispatch of electronic record is done. Now time of receipt. Now when have you received? So my dispatch is when I have sent. Your dispatch is when it enters in your computer resource. Okay. Now pay attention. If you have a designated computer resource, you have your own mobile, you have your own computer, you have your own software. Moment it has entered that resource. So let's say you have a designated computer resource, then the receipt occurs when the electronic record enters that designated resource. If that is not there, then when you have retrieve. If you don't have your own computer, you are borrowing someone, then whenever you get the message, that will be covered. So time of, if I go to just write, what is the time of, see, section 13 is talking of time of dispatch is when it is outside the control of the, originator, and time of receipt is when it enters in your own computer resource. But if you didn't have your own designated resource, then whenever you get that message from anyone. Okay. Then comes section number 15 and 16. 14, 15, 16. Okay. Now you are seeing secure electronic records. Tell me one thing, is every single electronic record secure? So what they are saying is, first, When the procedure has to be applied to an electronic record at a specific time, then such record shall be deemed to be secured from such point to the time of verification. We'll see. Then that's section 14. 15 says an electronic record shall be secure if it is in control of the signatory and the data creation device was stored in a manner specified, and the central government may be required to prescribe security procedures for electronic records. Now, let's see section 14, 15, 16. First is electronic, secure electronic records. There can be any method which will be specified in the act. Tell me why. Like law can never tell you, never in its entire life tell you that this is a secure method of preserving, transmitting data. Why? Because as technology changes, as technology is advancing, what is literally happening is there are so many different methods and procedures that will come. So section 16 is saying central government will prescribe security procedures for electronic records from time to time. From time to time. So maybe they can issue some ISO certification. Nowadays it is ISO 27001 which is application applied by companies. So if that is there, government can prescribe. Second, when that procedure is applied, it is said to be secure. And third, an electronic signature shall be deemed to be secure. Normally we will deem a deeming provision or a by default provision. We are saying that if the signature creation record, the DSC, is in control of the signatory and no other person, and the signature creation data, signature creation device is stored as prescribed. So all this very simple. Now remember one thing, we are doing one section, okay, where this I want you to note down. If you understand this, the entire chapter will become very simple from now onwards. Okay, so I want you to pay attention. Okay, so first thing is section 3 talks about digital signature. Section 3 talks about digital signature. Sir, what is digital signature? I told you, digital signature is normally when you have electronic records, you attach your DSC, okay, that or token is given to you. When so basically professionals like us, now pay attention to this, okay. Every electronic form, e-form for Companies Act, okay. Let's say for MCA perspective, e-form is there. You need to sign. So how will you sign? How will you sign? I'm asking you practically. I give you an e-form. I say it is in the computer. Sign it. Can you sign? So you say no, sir. I require some device. So to digitally sign, professionals apply to the certifying authority. That give me a DSC token. Then they send. You will give. They will verify your details. They will check whether you are eligible, and then dispatch a digital signature certificate. The DSC token. That DSC token I will insert it. It's like a pen drive. I will insert it in my computer. I will get a pop-up for my password. That is a private key. I will put the private key. Automatically it will come that the document has been signed, and my name will come digitally signed by XYZ person. Okay. This DSC is issued by certifying authorities, and if I have any issue with the certifying authorities, I will go to the controller of certifying authorities. So professionals are regulated by certifying authorities. They are our point of contact, and certifying authorities, if someone is not happy with the certifying authority, they will go to the controller. So controller controls certifying authorities. That's it. Understand this hierarchy, and the concept will become very simple. Okay. Now let's see. Certifying authorities. Okay, all provision with respect to certifying authorities are covered from section 17 to section number 34. A certifying authority. Who is a certifying authority? They have been certified by the controller to issue DSC token. Again, repeat. What is a certifying authority? A certifying authority has or certifies issue of digital signature certificate to professionals. When they issue this digital signature certificate, it is secure, it has a private key, public key, etc. Okay, that is there. To regulate certifying authorities. Now to regulate the certifying authorities, we have the controller of certifying authorities. Let's see. Electronic signature certificate. Now I'm not going to tell you, you have to tell me who. Now we want we require an electronic signature certificate. So who will professionals approach? Who will professionals, company secretary approach? Directors, company secretary. After clearing, you want to get to sign digital forms, you need to get a token. Who will you apply to? A controller or certifying authorities? Obviously you will apply to certifying authorities issue the digital signature certificate. So if anyone wants to obtain this certificate, they will have to make an application, they have to pay some fees, you have to give with a certificate of your COP number, your certification of practice, that who are you, why do you want to sign documents, and then the certifying authority, after looking at your certifications and see that if it is deemed fit, then they will issue a certificate. Clear? Done. Penal provisions have been given to you. Okay, so penalty clause have been given. If any person, so you can learn some general penalties to write it. Section 43 is a general penalty, that if any person without the permission of the owner enters into any computer or computer resource or computer network, so basically hacking, then punishment has been given and they have to pay compensation. Okay, so some penal provisions are given, you can read. Now we come to one important thing, which is compensation for failure to protect data. Market is important. Okay, market is super important. Compensation for failure to protect data. Nowadays companies collect data, so you also must have given your personal data to ICSI. What all personal data you must have given? It's a body corporate, na? Even ICSI is a body corporate. You must have given your personal data, your name, your address, your phone number. You must have opened your account on Smash portal. So even the Smash portal user ID and password the institute knows. So they have to maintain proper security procedures. If they are negligent in maintaining reasonable security, they can also be penalized. Now similarly, you must have given to Zomato, Swiggy your phone number, your address, your password, all of the details they have. Any app you download, you're giving personal data. So companies have to, which are dealing in sensitive personal data information, so what all it is SPDI, sensitive personal data or information. So any company collecting, any body corporate taking any sensitive personal data or information. Now what is sensitive data? We'll see the definition, but they include your name, identification, address, your biometrics, banks, they all take. Okay, so they can be held liable for compensation, is what they are saying, if they leak, if your information is leaked from yours. Nowadays there was a cases where Facebook was taking your data, where you used to put all your, what age you are, what qualification you have done, where you are, where you have signed in, where you have eaten. You're giving data to them of your whereabouts, and Facebook used to sell it to marketing agencies. So your SPDI, your sensitive personal data and information, is being sold. So for that they brought an amendment and they said, section number 43, that body corporates dealing with all of this have to give reasonable this, and if there is any loss they will have to pay damages. Okay, now reasonable security procedures means what? Reasonable means they should be able to, even if there has been hacking done on them, they will still be held responsible, because security procedures have to be maintained from unauthorized access, damage, use, modification, disclosure, impairment. Such security procedures will be prescribed by central government. Okay, now they've given you the penalty that will be there, that also you can learn. If they have, any company could not give, then their penalty provisions have been given. Now they've also kept a adjudicating officer, is like an investigating officer anytime. So adjudicating officer is appointed by the central government to investigate into any contravention, and this adjudicating officer can impose penalty if any of the companies are not following any law, not maintaining proper security procedures, not the SPDI has been violated, sensitive personal data and information is not been there, then he will award compensation. Okay. Now, if you are unhappy, very interesting point is here that the appellate authority. So you can mark this as your appellate authority. So we are seeing your so 45 and 60 days, remember, okay, that if you are unhappy with the decision of adjudicating officer, you can go and appeal to TRAI, Telecom Regulatory Authority. So there is a separate appellate authority. The appellate authority, we've said that TRAI is there. All the matters with respect to Secure Information Technology Act, appeals go to TRAI within 45 days, and from TRAI it will go to the High Court in 60 days. So first appeal is in 45 days to TRAI, and from TRAI to High Court it is in 60 days. So here you can take that who is the appellate authority. So chapter 10 talks about appellate authorities. Your telecom dispute settlement appellate tribunal shall be your appellate authority for this purpose. Any person aggrieved can appeal to them, and you agree with the certifying authority, adjudicating officer, controller, anyone, all the three agencies, adjudicating authority, certifying authority, or controller. You are unhappy, go to TRAI to in 45 days. Any person agree from TRAI can go to the High Court in 60 days. Okay, and then they've given you a few offenses you will have to read: tampering with a computer source, etc. Now, one more important point they have added is about liability of network service providers. This point we've already covered, and same point will be repeated. Network service provider means you're watching your particular video through some network, right? Internet. Which network are you using? Jio, Vodafone, whatever. So that's a network service provider. Internet service providers. So they also have to ensure that they are nobody is using Wi-Fi, using internet to hack. No person is using Wi-Fi, etc. to hack into any banking system. So they also have to develop some standard procedures. And if they are negligent in giving security measures, even the network service providers can be held liable. They are intermediaries, right? They give you Wi-Fi access to talk to someone. Now they will not be held liable. An exception is there if they prove that they maintained all the security procedures set by central government, and someone must have hacked through some advanced method, and it was not due to their knowledge or negligence. Now let's see liability of network service providers. So you have your Jio, you have your Vodafone, etc. They are all network service providers. Now you are using, let's say this is you, this is a user, and let's say you're watching YouTube, right? So this is you and you want to contact YouTube, but you need to do it through a intermediary help you require. That intermediary is your network service provider. Internet access is needed. Okay, so internet based services that are there, entities which help you connect to the internet. So what is this? They are entities that help you connect to the internet are called a network service provider. So any intermediary, so they are intermediaries, must maintain from whom any other person is receiving, storing, transmitting information, including telecom service providers, network service providers, internet service providers, web hosting service providers, so multiple service providers, online service providers, cyber cafes, etc. So they are all intermediaries. All of them are covered. Okay. The liability. Now the question comes, you understood what a network service provider. So it could be even your cyber cafe, they are providing you network. You go through Razorpay. So it is a payment network provider. So all of them, their liabilities there may arise whenever there is a violation of a trademark, copyright, patent, etc. Imagine if someone has hacked the account and taken a trademark, copyright, etc. has been done. So they can be liable for any copyright, trademark infringements, trade secret, tort, etc. Now, to avoid such consequences, they have said the Act declares that no network service provider shall be held liable if the offense was committed outside his knowledge and he had done full due diligence to prevent the commission of the offence. This is under section 79. Mark it as important. Then again they've added one simple point which is about we've already done this, that security SPDI, sensitive personal data and information rules. What they have said that section 43 offers compensation whenever your SPDI is leaked. Now it was seen that the act says that first few points, that consent has to be taken whenever you're taking SPDI. Only limit it if data needs to be taken. Do not take data to SPDI if it is not, requirement is not there. Grievance resolution should be provided. A grievance officer should be there. Data should not be transferred without the consent of any person, or express consent should be taken before taking them their data. And they are saying the data privacy rules should be put on the website. So we're just seeing some of the SPDI laws, and you should provide proper security procedures also. So what are we doing? So first, all the SPDI special this what all points are there. First, the policy, SPDI policy should be on the website. Second, before taking SPDI you have to take their consent. Third, you have to provide reasonable security practices should be followed because you're storing this. Fourth is you should not transfer, no transfer should be done of their information. Fifth, we can say, let's see any other points. You should have a officer, grievance officer, and his name should be disclosed on the website. This is all with respect to companies that are taking sensitive personal data and information. So with this we've completed the entire chapter on Information Technology Act 2000. Thank you. Okay, clear till here? Okay, clear? We are done with this chapter. Is it clear? Write clear in the chat box so we can start with the next chapter. And don't worry, BSA Act also will be taken and uploaded not only in the app. I will also put it on YouTube. Till here it is clear, yes or no? Yes. Now someone is asking, can we put short answers? Answer is yes. All the keywords you put, because on an average in JIGL your questions will be for 5 marks. Now when I say 5 marks means you will write at least one side. One side is a minimum. So we write the introduction of the act, a little bit there. It is enough. Okay. So that is it. Now we start with the next chapter and complete it. So we've completed more chapters. Okay, with God's grace, great. Sneha, thank you so much. If you not like the video, like the video. If you not shared it with your friends, share it. Let's see. Next. I'll take one more chapter and complete it. I'll take your registration of documents. Now I'll take my registration of documents and complete it. Okay, registration of documents, and I will take and complete it. So we finished torts also. So many chapters I've already covered. Remember that all this you will get in my marathons, previous marathons also. Okay. Now, let's see. So now I've finished your Information Technology Act also in depth I've covered. Now I'm going to take your, where is the Registration Act? Hmm. 13th chapter. Now I'll take the 13th chapter and knock it off. Let's see your Registration Act. Okay, so we'll take a break of 10 minutes and then we'll start. What's the time now? So 10 minutes break and then we start and complete your Registration Act also. Okay, so am I audible and visible? Can I have it in the chat box quickly? So we can start and complete this entire chapter. Okay, can I have in the chat box quickly, so then I can quickly start and complete? Okay, great. So we'll be starting. Just mention that I'm audible and visible, and I will quickly start. Okay, great. Shri Ram, thank you so much. Arun, great. Let's begin. Hi. So we start with a chapter called as Registration Act 1908. Now, what is the Registration Act? Registration Act is an act which compulsorily requires certain document to be registered with the government. Only when this requirement of registration is complete, we will hold certain transactions as complete. Otherwise, the transaction is not completed. For example, when you go to buy a home, so there is a sale of property, okay, sale of a house. So registration is mandatory. You have to go to the registrar's office wherever your property is situated. You have to tell them, and then only the registrar will substitute the name of the seller from the buyer, and the buyer's name will be completed. So only it's a formality to make certain documents, to make certain transaction will be valid only on registration. Okay, so what do you mean by registration? With whom am I registering? So registration means to register, store, or file the document. Registration means to file the documents with government department. Okay, so it will be mentioned, government will come to know that the ownership has changed, and it will be preserved into the thing. Okay, now whenever, very simple, whenever you buy a home, I don't know whether you know that two mandatory legal requirements are there. The first is stamp duty. Stamp duty on that property has to be paid, and second, after paying the stamp duty, the registration of that document, sale deed, proof of stamp duty is given. Okay, on registration, that document or the transaction becomes completed. Now we see that there are two key sections under the Act. One is section 17 and the other one is section number 18. Section 17 covers all those documents for which registration is mandatory and compulsory. And section number 18 covers those documents for which registration is optional. Okay. So section 17 covers all those documents for which registration is compulsory, and section number 18 covers all those topics for which registration is optional. Means what? If any document is coming under section 17, I have to mandatorily, compulsorily register it. If I don't register it, then the transaction is not complete. So the other kinds of transactions are optional, you may or may not do. For example, let's say purchase of property. As I told you in the beginning, purchase of immovable property. Now when you buy a house, it is mandatory registration of the document. Why? Because it is given in section number 17. Another type of document, if I say, if you have a 1 year rent agreement, again you will see that registration is mandatory. But let's say if I purchase a watch, a Rolex watch, registration is not required for such kind of transactions. Okay, so very simple, we will see. Now first, which documents require compulsory registration? So I want you to note down with me. So section 17 subsection 1 contains a certain kind of documents for which registration is compulsory. The very first one is a gift of immovable property. So in gift there is no consideration involved. It is given out of love and affection. Okay. So here a gift of an immovable property requires registration. Now, the person who gives the gift is called as a donor, is the giver of gift, Okay, and the person who's receiving the gift, the receiver, is called as the donee. Now there is a case law of Kalyana Sundarapam versus Karuppa. In this case law, what is told, that if the donor has done everything during his lifetime to make the gift, he has done everything, he's made a document, he has signed, and he has paid the stamp duty also on it, and before registration he dies, and before registration he dies. So law says that, listen, the donor during his lifetime has done everything to register it. Just because on the date of registration he is not alive, don't reject the registration. It is the man's last wish, completed, accepted. So what they have said, the donor dies before registration, should we accept or not accept? They are saying that it will be registered, and will be registered as he is alive. It will have the same effect as if it was registered during his lifetime. Okay, so in Kalyana Sundarapam versus Karuppa, while registration is necessary, okay, it does not suspend the gift until the registration actually takes place. Okay, so registration is mandatory. It does not cancel the gift. It doesn't mean the gift is not valid till registration is there. It is just a requirement which is to be completed. Okay, so as the example I had given you, when the donor had done everything, he handed over the property, he did everything in his power during his lifetime to make the gift effective, then even if it is presented when he is not alive, it will be accepted. Okay, then came another thing. So which is the first point, section 17 subsection 1, gift of immovable property requires registration. Now to learn this line, I'm going to tell you something, that one common line I want you to learn. Just before that, what is the second point? It is a value of property which is 100 rupees or upwards. So whenever there is a transfer, sale, etc., transfer of immovable property of, now the consideration is involved, 100 rupees or upwards. Now obviously 100 rupees, all the properties are 100 rupees and more, immovable property. Therefore all properties require registration. Now this act was made in 1908, and that is why 100 rupees they have mentioned. Otherwise they have not changed it, only because they want all immovable properties to be registered. Transfer of a immovable property of 100 rupees or upwards. But how have they said? Remember this line, okay? Whenever there is a, now before this there is a words, I want you to learn it and write it down with me. Whenever there is a CDAL, okay, of RTI, whether contingent or vested, okay, of vested or contingent, okay, vested or contingent, I want this line to be written as X, and multiple times it will come in the exam in the particular section which you have to quote it. So whenever there is a creation, declaration, assignment, limitation or extinguishment of any right, title and interest which is either vested or contingent, and now you write simple words, of a value of 100 rupees or upwards or immovable property, such requires mandatory registration. So whenever there is a CDAL of RTI, whether vested or contingent, of a immovable property of 100 rupees or upwards, means what are they trying to say? Whenever there is a creation of a right, okay, in a immovable property of 100 rupees or upwards, it needs to be registered. Okay, now they've given you more case laws which is very, very simple. A document which is plainly intended to be operative immediately is a non-testamentary this, and very, very important, non-testamentary. Non-testamentary means what? A non-testamentary means not will. Not will. So will is called as testamentary document. Will operates after my lifetime. But imagine if I made a document and I wanted to be, is plainly intended to be operative immediately, not at the death, is obviously not a will, is what they have given. Very simple. So now I just want you to remember a non-testamentary document. So a will is not covered under compulsory registration. will requires optional registration. So a testamentary means a will. So non-testamentary means not a will. So any document which is not a will, in which there is a CDL of RTI, of 100 rupees upwards, requires mandatory registration. Now same line, everything you have to write, but just the receipt. Now normally when you make a payment through check, through RTGS, you also have for example, I'm buying a place, immovable property, so I'll make a receipt, right? So even that receipt needs to be registered. So even a receipt by which a immovable property of 100 rupees or upward is being transferred also has to be registered. Third, a lease of more than 1 year, year on year, more than 1 year, yearly rent requires compulsory registration. That is why you will see all rent agreements are of 11 months. Because if it is 12 months or more, it requires compulsory registration. D. Now we see the E point. Now same points of 100 rupees in immovable property, 100 rupees over, but it's a transfer of a property happening on order of court. So if the court has ordered to be transferred of an immovable property of 100 rupees upwards, requires compulsory registration. So we are done. There are 5 points. Okay, 5 points. Which are the 5 points? A gift of immovable property requires compulsory registration. Immovable property of 100 rupees upwards requires compulsory registration. The receipt of that property also requires compulsory registration. A court order transferring immovable property of 100 rupees upwards also requires compulsory registration, and a lease of 1 year or more also requires compulsory registration. Only the key word I have told you to learn: whenever there is a non-testamentary document, in which there is a CDL of RTI, whether vested or contingent, this line I want you to learn and write it as X. What you will write it as? X. Everywhere you will fit it. You will fit it here, point 2, point 3, point 4. All the 3 points you will use point number X. Perfect. Beautifully explained. Now we go to subsection 2. Sir, or subsection 2. Okay. Very, very important. Now section 17, subsection 1 we did, which requires compulsory documents. And now they have said subsection 2. They give you certain documents for which registration is optional. So section 17, which normally talks about compulsory registration, is telling you that some documents above have been exempted by law. So above, if the section 17 subsection 2 would not be there, all the documents above would be registered. However, from those section 17 documents, some documents have been made optional. So some of the section 17 documents from what we did now have been exempted. And it's a very simple logical thing that you will make out. Okay. First of all, if government is the transferor or the government is involved, so then they will say registration is not compulsory, we are only involved. So you will see some points which is there. Now when registration is not needed, so for the following things you have to remember, note it down, some few points and done. Okay, so it is important. First, any settlement, so composition deed means a settlement deed. So with your debtor, creditor have made a settlement deed, registration is optional. Now when you see, as a company secretary, you deal with shares, debentures, okay, all of those securities, right? So all these three are about security. So when these securities are being transferred, we know now as a company law, you don't have to go to register anywhere. Nowadays you can directly buy, sell shares, debentures, etc. So that is allowed. No compulsory registration, we know that. Now I told you one thing is when it comes with respect to government. So when government is involved, revenue officer, it's also with the government. Okay, Land Improvement Act, again with respect to that is same. Agricultural land, Charitable Endowments Act. So all these have been exempted. So any transfer of immovable property with respect to government, revenue officer, Land Improvement Act, Agricultural Acts and Endowment Act have been exempted. No compulsory registration. Even with the revenue officer, same points, that is exempted. Now we see exactly opposite of section 17 is section number 18, which says when registration of documents is optional, it's not compulsory, it's optional. So for example, all those points in section 17, if you just reverse it, you will get section number 18. For example, instruments which have less than 100 rupees. receipt which is less than 100 rupees, court order which is less than 100 rupees. Now everywhere it has written immovable property. Your movable property is also optional. Will, because every time they should write non-testamentary, means not will. That means will obviously come under section number 18 optional. Any other documents which do not fall under section 17 require optional registration. Now time limit. Now pay attention to the time limit. Okay, time limit for presentation. Time limit for presentation. Time limit for presentation. Now, if a document has been registered, let's say if a document is signed, so let's say there is the buyer and seller. They both have decided to, and this is the house. So they both have signed. B has also signed and S has also signed. Now this signed documents has to be presented before the registrar or the registering officer within how much time? So the answer is 4 months, and an extension can be given of another 4 months if due to any reason, personal reasons, emergency, urgent reasons, you couldn't come. You had some urgent personal commitment, you couldn't come. So in that case, we will say we give you more 4 months. So 4 plus 4 is 8 months. Done. This is an urgent necessity if you had to be somewhere else. Understood. So a document must be presented within 4 months of its execution. Sir, execution means what? Execution means signing. Execution means signing. So within 4 months it should be presented. If there is any urgent necessity, etc., it will be presented within more 4 months. Extension is being given, but higher fees is to be paid. Time limits are mandatory. Okay, has been given in this case. If a delay is due to act of court, it can be overlooked, can be allowed that delay. Unstamped document. Now I told you, whenever you go to buy a house, you will first pay stamp duty, then take that stamp duty and with a full sale deed, you will go for registration. If the stamp is underpaid, then it is still good for presentation. We will still accept it, but we will tell you to pay the stamp duty and put some penalty also. If the government realize that you underpaid the stamp duty, they will accept it for registration and tell you that pay the balance stamp duty along with penalty. Now re-registration. What does re-registration mean? Re-registration means a person other than the correct person has come for registration. Normally buyer seller will come or the agents will come, but if someone else has come, then they will say it is wrong, you please go. A person not duly authorized, you don't have power of attorney, how are you coming? Brother has come, sister has come without any document. So we will say that registration dates are normally given, that on this date you come and register the property. If for that wrong person has come, then they will give another date. That is called as re-registration of document. So it deals with situation when the original presentation is given by a person not duly authorized. So the presentation for registration has come by a person not duly authorized, means the right person should go for registration, otherwise re-registration will be done. Simple. Several executants. Okay, now if there are multiple parties, then obviously within 4 months from each date of signing you have to get it registered. So normally parties sign on the same date, or maybe one sign today, another sign tomorrow. Then within 4 months of each signing you have to ensure it is registered. If a document is registered outside India, now we are talking of, let's say you're going on a foreign trip and there you decided with a party that you want to sell your house. So the agreement was entered outside India. So it is given 4 months, sir, 4 months before also, but not 4 months from signing, 4 months from date of arrival in India, date of arrival in India. So whenever the document has arrived into India, within 4 months your time of registration starts. So section 26 talks that the document was executed outside India. If the document was executed out of India, it will be presented for registration within 4 months after its arrival into India. So it will be registered, it will be presented for registration within 4 months after its arrival into India. Or document executed outside India is not valid unless it is registered in India. Simple. So a document executed outside India is not valid unless it is registered in India. Simple. Next, Okay. Okay. Place of registration. Now, where will you go to register? Obviously, where the property is situated. So, very simple, where the immovable property is situated. Okay, in whoever's jurisdiction it is presented. So, for example, if the registrar is here, okay, let's say the property is in Mumbai, you will go to the Mumbai registrar. Common sense. So, you will go, place of registration is where the immovable property in whose jurisdiction the property is situated. You go to the registrar in whose the you will go to the registrar office if property is even some portion of the property is situated in his jurisdiction. So if property is situated in whoever's jurisdiction, you will go to that. Obviously, where else will you go? Registration of property elsewhere is void. Now, if your property is in Mumbai, I go to Rajasthan and that guy accepts it also, it is void. It has to go to the registrar in whose jurisdiction full property or even a small portion is situated, it is allowed. Now, presentation of documents. Now, very important, presenting of documents for registration. Who will present? We remember we had done the correct party should come. So it will be the person himself, his legal representative or his agent. Okay. So section 32 says that persons who can present the document for registration. Persons who can present the document for registration is the person himself, it is the representative or it is the agent. Now comes registered document when operative. Market is important. Now there is a concept also, understand, huh? That let's say if the date of signing, or I'll call it as execution, that is signing, is 1st Jan 2025. Okay, 1st Jan 2025, date of signing, and date of registration, let's say it was registered, it had to be within 4 months, right? So let's say they have registered next month only. Now I want to know from which date the document will be affected, operative. From which date the document will be operative? From the date of execution or the date of registration? Quickly, what do you think? So the answer is, no doubt this is a procedural formality, the signing and everything has been done, so it will be operative from 1st Jan 2025, from the date of execution and not the date of registration. Obviously, because if the property has been signed, stamp duty has been paid, possession also must be given, so we will say that it has been effective from this date and not the date of registration. Registration is just a legal formality. Okay, but obviously the deal has been done on the date of signing only, na? So pay attention that a registration document shall operate from the date of execution. Simple. So it will operate from the date of execution. Second, as between two registered documents, the date of execution will determine priority. So let's say if there has been fraud where one property has been sold to one, let's say there has been one property sold to two people, okay. Now builder is a fraud, he has sold one property and he gave to one person, he took money from the first person and the second person also, and he ran away. Now the question comes that both these buyers are there, they both have paid consideration, in whose name the property will come? So let's say dates will be different. Okay, if the dates are different, then the one with whom the date of execution, whoever has a earlier date of execution, date of signing, will get priority. So obviously registrar will say that whose date has been coming first. So whoever has come with the earlier date of execution, date of signing, his document will be registered and the other one's document will not be registered. Okay. Now date of execution will be seen even if someone else has come earlier for registration, other one also came later, but we came to know still the deciding factor will be date of execution. Okay. So if a document has been executed at two different times, the one with whom the first signing has been done, earlier signing has been done, will get priority. Now let's say if effect of, now remember the section also, effect of non-registration, very important, that if a document which was required to be registered was not registered, or document which was required to be registered was not registered. So let's say a property which was there was signed between the parties, sale deed, but sale deed was not registered, then what will happen? If will happen, it will not affect the immovable property. Okay, it will not get and give any power to anyone, and it cannot be taken as evidence in court. So three things: if document is not there, no power will be created, cannot affect the immovable property, means it doesn't, nothing changes on the immovable property, and it cannot be taken as evidence in court also. Remember the word APE. So a document, no document shall be which is required under section 17 to be registered shall affect any immovable property, confer any right, or be taken as evidence unless it is registered. Now there are two exceptions, that even if a document is, two exceptions are there where it can be taken as evidence even if registration is not complete. So can be taken into evidence even if no registration. So one is specific performance and the other one is part performance. Okay, so part performance comes in Transfer of Property Act, specific performance comes under the Specific Relief Act. Now obviously buyer seller, they have done a deed, now the other party not coming for registration, so they can sue that person and say that, see, I have a sale deed, I made the payment, but this guy is not coming for registration. Then the court will order a specific performance, so that much evidence is allowed. And part performance is a separate concept under section 53A. So in these two cases, even if it is not registered, it can be taken as evidence in court. Okay. Now miscellaneous books. Now obviously the registrar of properties will maintain where books of all the documents that have come, which for registration, how many wills have come. Okay. Or where he has refused, book 2 will be counted. On granting this, a certificate of registration will be given. Okay, certificate of registration will be given when you are there, and it will come that certificate will be given and signed by the registering officer. Okay, and this is a prima facie evidence that the document has been successfully registered and all the formalities are completed. If you are unhappy with the sub registrar, you can go in appeal to the registrar within 30 days. So from sub registrar you can go to registrar, and from registrar you can go to the civil court. 30 days. So this is the appeal provision, 30 days. In case of this also you will go, so registrar refuses, then you can go and appeal to within 30 days to a civil court. So this is the hierarchy. Okay, with this we've completed your entire Registration Act 1908. Thank you. Now there is another part which is your Transfer of Property Act, that you can see it from the app. That's a completely different act altogether. Okay, so some provisions you can see from the Dream Batch. With this I'm completed with this chapter also. Now let's look at the next chapter that we can knock off. Let's see if I can complete this. Okay, so we'll after the lecture we'll come and we'll complete your Specific Relief Act. Okay, so we'll complete your Specific Relief Act. So I've completed your, I'll complete your Specific Relief Act after the break. Okay, so Specific Relief Act will be completed after the break. Okay. So till now, is everything clear? Yes or no? I just want you all in the chat box. Is it clear? Just write the word clear in the chat box. So I will take and complete the next chapter. Yes or no? Quickly. Clear in the chat box. So I will start and complete the next chapter also. Almost everything I have completed for you all. Okay. For this dream batch you get, everything is completed. Okay. Great. Arun, thank you so much. So now we'll just come back in 10 minutes and then complete this other part also. Rajat, great. Hi guys, am I audible and visible? Quickly so we can complete the particular chapter. So we'll be starting and completing the entire Specific Relief Act 1963. So can I have in the chat box if I'm audible, visible quickly so we can start and complete the chapter. Okay. So in this chapter, whatever we'll be doing, that much you do, it is sufficient. I will be covering everything. Okay. I want GTG in the chat box so I know that I'm audible, visible so we can complete the chapter. Quickly. GTG in the chat box. Okay, great, Arun. Thank you so much. Let's begin. Hi. So we'll be starting with a chapter called as Specific Relief Act 1963. Now before I start, let me tell you what does this chapter contain. Okay, Specific Relief Act 1963. Okay, all your questions will be framed from this only. So I'll tell you what all around 4-5 things you need to do, and your full chapter will be covered from here. So very first one they start. This is a Specific Relief Act. They talk about recovery of property. So one question they can ask you is recovery of property. Okay, recovery of property could be you are trying to recover your immovable property or trying to recover your movable property. Okay, movable property. Simple. Second question that they can ask you is a specific performance of contract. The second part they can ask you is your chapter 2 is when specific performance of contract can be ordered. Then we'll be seeing your main chapter, which is your specific performance of contract, when it can be ordered. Okay, when it is allowed. Third question they can ask you is when, you know, like when it can be allowed, when allowed, when not allowed. Okay, and whether partly it is allowed or no. So these, whichever I'm doing, only from your question can be framed. The next thing is they'll ask about 3 things, which is rectification of instruments, recession and cancellation of instruments. So question can be framed from your. Next, if we see the fourth one is declaratory decree. The fourth is your declaratory decree. Okay, this can be asked. And the fifth one is your injunction. Okay, so your full chapter or any exam question will be framed from here only. Okay, so all this, if these things we do, it is covering the full chapter. Let's begin. Okay, Specific Relief Act. Now what do you mean by Specific Relief Act? Understand, whenever there is a contract, or breach of contract, parties get relief. There are 2 kinds of relief that you can ask. The relief that you can ask in this is 2. One is you can ask for compensation. You can ask for compensation in terms of money, where you can say give me money for compensation for breach of contract. Simple. The other thing you can say is that I don't care for money, I don't want money, I want the exact same thing what has been promised. So when you ask that compensation of money is not sufficient or the party rejects it, then in such case they can ask for specific relief. Now what is this specific relief? You tell the other side to honor the contract. So for example, I entered into a deed, I entered into an agreement for purchase of the house. Now you had told that you will sell, and at XYZ price we entered into a agreement. Now you are backing out from the transaction, you are saying you don't want to sell. So law says you take this compensation. I say no, I don't want compensation in terms of money. I want the exact same thing that is promised. That is called as specific relief. Okay, now let's see. So Specific Relief Act applies both for movable as well as immovable properties, and court can order specific performance when they feel that compensation is not going to be sufficient. So they ask for the exact fulfillment of the obligation. So what is Specific Relief Act? You are asking for fulfillment of obligation. Fulfillment of obligation. Now, as we saw in the chapter, before we get into the actual specific part, specific relief, which is in your part 2, we are going to see one recovery of property concept. Let's see, if you want to recover your movable, immovable property, what it is. So the sections that are covered is your section number 5 and 6. Your section 5 and section number 6. This is for recovering your immovable property. So the first, before we get, I told you 5 different parts are there. First part is about recovery of movable and the immovable property. Let's see. When I have given my house on rent to someone, that person is not exiting the house. Okay, so I have given a person to stay. So I have transferred possession to you to stay, and now you're not leaving from the house. So I want to recover the possession of my immovable property. Can I do it by force, or I have to follow procedure by law? So obviously you cannot do it. You cannot take the tenant and just throw him out and take the law in your own hands. It will lead to violence, etc. What you need to do, you need to file an eviction suit and follow the civil procedure code. And you have to file a suit within a certain time. For this specific relief that you are saying that please get him out of the thing, I have to file, so let's say if a person, tenant, has been dispossessed. So there has been a dispossession from the house by the owner. Owner has come and he has kicked him out. So I will tell the court to restore me back into the house as it is, because he has not gone to court, not follow the procedure. I have to file this thing within 6 months. I have to file an application within 6 months. So who will file? So anyone who is dispossessed. Who is what? Dispossessed. Dispossessed of immovable property. So for example, I was the tenant. I was forcefully removed from the house. So I will file a case on the owner that the owner has not followed the procedure. He has removed me. I will tell the court, please give me back my possession. The reason is I was not removed, evicted through the civil procedure code. So let's see. A person who is entitled to possession of a specific immovable property. So anyone who is entitled to immovable property. Okay, so the owner is entitled to immovable property. He can recover it only through the Civil Procedure Code 1908. So a person who is entitled to possession. So the owner, if he wants possession, he can do it only through Civil Procedure Code. If the owner does not use it and he disposes anyone without his consent, he can recover the possession even if any other title is set up in the suit. Such suit shall be brought within 6 months. So even if someone else is the owner, I can say that bring me back into the case because civil procedure code was not followed. No suit can be brought against the government. 6.1. Okay, so government, you cannot file a suit, and even unlawful possession can be taken only by lawful means and not forcefully. So even if unlawful possession, so I'm going to tell the court that listen, I'm the owner, I'm telling that see, this guy is unlawfully staying in my house, it has tenure is over, still he's staying. So law says even if it is unlawful possession, it can be taken only by lawful means. So this we are telling the owner that listen, even if we know that the tenant is overstaying, tenure is over, still he's staying, we cannot kick him out directly. It can only be taken by lawful means, that is by following the civil procedure code. So they are telling the owner that you can get your property only by civil procedure code. Okay, even if it is the tenant is unlawful, you can only take it through lawful means. Okay, and if you dispossess him, then the tenant will file a case that within 6 months he will say that please give me possession, I have been dispossessed wrongfully. Done. Then comes now this with respect to movable property. Now if someone has your immovable property, For example, you gave your friend, or maybe you had gone to Goa and you took a bike. Now that bike is a movable property, owner has given you the immovable property. The owner of the Activa has given you for riding it. Now you're not returning it back. So they are saying that the owner will go to the court, and the court will tell the person that, listen, you have to deliver it because you're not the owner. So your court will directly tell the person that give it to the owner. So a person who's entitled to possession of movable property. So let's say a owner will get it in the procedure of civil procedure code. So even if a person who's entitled to possession of a movable property, let's say the owner, he is entitled to movable property, he has to follow the civil procedure code. Simple. Second, if any person is in possession of or control of the specific immovable property and he is not the owner, so if they find anyone in possession who is not the owner, then that guy will be compelled to deliver it to the person entitled to immediate possession, that is the owner or his agent. So if I have gone to Goa and I have taken someone's bike and I am now taking it for a longer time without his consent, so the owner can take it through civil procedure code, and in civil procedure code also they are saying that court will tell that the court will see that whose possession it is. So I'll say he is not the owner, he has the possession of my bike. So if he is not the owner, then that person will be compelled to deliver it to the owner or his agent. That is the rule. Okay. Next, now we come to specific performance. Okay, specific performance of a contract. As I told you that first part is over, your taking possession of movable and immovable property. Now we see specific performance of contract. So here we have done section 5, 6 and 7. So section 5 and 6 is about recovery of immovable property. And section 7 is about what? Is recovery of movable property. Clear? Now we are going to see the next thing, which is called as Specific Relief Act. Your specific performance of a contract. What does this line mean? That compensation. So if there is a breach of contract, okay, and in the breach of contract, one party is saying they don't want compensation in terms of money, it is not adequate relief, they are not happy with compensation, whatever he is promised, tell him to give. That is called as specific performance. So specific performance of breach of contract means what? That whenever there is a breach of contract and compensation is not adequate relief, then court orders specific performance. Okay, now it is at the discretion of the court. So specific performance can be ordered at the discretion of the court. In the following cases. Now when all court will order this? First is, we cannot, there is no standard for ascertaining the damage by non-performance. So if the party is causing the breach and we cannot find how much loss will be caused due to non-performance. For example, if my one painting is there with which, or I'm buying a house, okay, and that house is somewhere I'm emotionally connected with that house, I've given money to buy it. So I will tell the court that, listen, if the breach is there, the damage is not there, you will not be able to find how much damage is done to me. Okay. So where there is no standard for deciding the damage because of non-performance, the court said this is a very big issue, we will not be able to find only how much money to give with such a big loss. Okay. So let's say if order is there because of which you could give the exam or you could go abroad, and that is only not allowed. So if your exam is only not allowed to be given, that will be cause irreparable loss for which we cannot cause. So let's say you had purchased a particular Ola Uber that you have to transfer me to the exam hall. So if that contract is breached, it will not be able to, court will not be able to ascertain how much damage has been done. So this is one example where damage cannot be identified by monetary terms. Next, where it is the act agreed to be done, that compensation in terms of money for non-performance will not be sufficient relief. So one of this, obviously, when your compensation in terms of money is not sufficient relief. And third is when you are trying to deal with an article which is not in ordinary commerce, it is sold. So one is where compensation will not give sufficient relief, damage is not able to be ascertained, and third, the movable property is not a ordinary article. So if you are dealing with, let's say, a lamp or a painting which your father has made, so for you it is an emotional connect. You cannot go and buy the same painting in market because that painting your father must have made. So 3 points are there. So court normally orders specific performance. So specific performance can be ordered in the following cases. Specific performance. First is you cannot ascertain the damage. It's that way. Second, compensation in terms of money will not be adequate. And third, the movable property is not a ordinary article that is can be purchased in market. So these 3 conditions are there. Court will say that at the court's discretion, order will be given. Next, specific performance of a part of a contract. So very interesting case has been given. Okay, that if a contract was there, so there was 100 bighas. Now bigha is a acre of land, you can understand. Turns out that 90 bigha the owner had and 2 was of stranger. So what happened is 100 acres of land was there, for example, bighas. Out of the 90 acres was of the real owner and 2 owners was someone else. So specific performance can be ordered for the 98 acres. That, listen, 98 acres is yours now. You had contracted to sell, now you have to give it. 2 acres which was not yours, for this compensation in terms of money can be given, and for this specific performance can be given. So the point is, as per section 12, specific performance of a part of a contract can be given. If the major part of the contract, specific performance can be given, and for the left portion, compensation of money can be given. Next, contracts which cannot be specifically enforced. So now these contracts cannot be specifically enforced. That means court cannot order specific performance for the following contract. Very simple. Where will not order? Okay, so specific relief is not ordered in following cases. Now see, first is very important thing, that if the compensation in terms of money is sufficient, then court will say that give the compensation. We will not ask the other person to do what they have said. Because let's say if we'll say that he'll give you money, you go and buy it from the market only. Now why you want to harass him? Second, if the contract runs into such minute details which the court cannot enforce, means if a contract is there, has minute details which the court cannot enforce and oversee all these aspects, the court will not give. So contract runs into, so it's a very complex contract, we will not enforce. Contract which is in the nature determinable means terminable. Means the party in a service contract, party has an option to give 1 month notice and leave the job. So then you cannot force the employee to work, because contract itself, it is said that it is terminable by notice and the party is doing, then you cannot enforce it. Next, contract of performance which involves a continuous duty of the court and the court cannot supervise. So any contract which requires court to continuously keep monitoring, they will not do. And last is specific performance which is of a personal nature. Husband, wife must have agreed on something. So we will not involve. It involves personal things. So first is, if you go to see it, money is sufficient. Second, we see it's a complex contract, runs into multiple details. Third is, it is terminable or determinable. The party has a right to terminate. It requires continuous duty of the court, and it is of personal nature. In all these cases, court will order compensation in terms of money and not specific performance. Okay. Now, so we are doing the second part of the chapter, against whom it can be done, or when compensation will be ordered, etc. Now we are seeing one thing where persons against whom specific performance cannot be ordered. So against whom it cannot be, against persons against whom specific performance cannot be enforced. Specific performance cannot be enforced in favor of a person. So who cannot get the benefit? Get benefit under Act. Now just imagine, if I have only not done my duty, will I get? So any person who is not entitled to recover compensation, court will not give order specific performance in his favor. Second, who has become incapable of performing or violates the essential term. If a person himself violates the term, he will not be allowed. A person who fails to declare that he has performed the essential part. So here we are seeing that any person is not coming with clean hands. So if you have not come with clean hands, court will not order a specific performance order in your favor. So you are not allowed to get compensation. Then obviously you are not allowed to get specific. You are not allowed to ask for compensation also. You're not allowed for compensation or allowed specific relief also. Common sense must be a third party who is coming to claim the benefit. Okay, now against whom specific performance may be enforced. So the section 19 is talking about against whom specific performance may be granted. Means court will tell the following persons that listen, you have promised, you do it. So any party can be ordered specific performance that you do it. Any person claiming under him, so any agent is there, he can also be told that listen, your boss had promised, you do it. Where it is a company, LLP has entered, they can be ordered. A company can be ordered. Promoters can be ordered. So very simple, anyone, whether it be a person or a company or LLP, they can be ordered. Now again, specific performance, okay, is a discretion of the court. Is discretionary remedy, and you cannot order the court to give specific performance. Now, other cases where court can order specific performance. Now, we are going to see three cases of. Now, pay attention. We finished the second part of the chapter also. What is specific performance? When it is ordered, when it is not ordered, in whose favor it is ordered, and against whom it is not ordered. Very simple. Anyone who is not coming with clean hands, he will not get. Anyone, it could be given. When it is not allowed, when compensation, running into, all those points we have given is the second part of the chapter is also done. So only question will come from these parts only. Recovery of movable, immovable, specific performance. Now the third part we are doing is rectification, recession, and cancellation of contract. Now this is the next part of the chapter that we are doing, rectification, recession, and cancellation of contract. Okay, let's see. Now what does rectification mean? It is section number 27. Rectification means so order rectifying an instrument if it does not reflect the intention of the parties. So if any instrument is not reflecting the intention of the parties, it can be rectified. Okay, this could happen. Why the intention didn't come? Maybe it could be a mutual mistake or it could be a fraud. So whatever it is, it did not reflect the intention of the parties. Rectification means correction of an error, okay, to give the real effect of the intention of the party. So we go and rectify this instrument and listen, with this contract we entered, both of us made a mistake. We want go into the court to make the correction. So the court will order correction of that documents. Okay. So section 26 talks about rectification of instrument. It is provided that when a contract may be rectified. So whereby fraud or mutual mistakes, it does not reflect the intention of the parties, parties can apply for rectification. Okay. No relief will be granted unless the claim for until the parties claim for rectification. What does it mean? That court will not come and give rectification. Some party has to come forward and parties will come and ask that please order the rectification of instrument. So parties themselves are saying that they want the court to supervise. So then we will order the real intention to be disclosed. Now very simple. So when the intention is not, when the contract or the instrument is not reflecting the real intention of the parties, parties can approach the court to mutually make the correction in the instrument. That was section number 26. Now we are seeing section number 27. It talks about recession. Recession means to recess, to take back. It's putting an end to a contract which is still operative and making it null, void ab initio. It does not apply to void contracts. Now understand, that means it applies to, if it doesn't apply to void contracts, it will apply to voidable contracts. Voidable contracts. Let's understand the simple. And it is still operative and you want to apply it and make it void. You can making that document null and void. Very, very simple. Okay. Let's say if there is a voidable contract. Okay. You ordered a red car, but a black car came. Okay. So wrong delivery was there. Now it is up to the aggrieved party to decide whether to keep this car. So he has an option whether to make the contract valid or to make it void. So the aggrieved party can keep the black car if they want, so they can pay the money and make it valid, or they can then go to court saying that listen, we had an agreement and it is voidable in nature, so you will make it void. So the aggrieved party who is there will say that listen, the contract is still operative, it is a voidable contract, I have that right to make it void or valid, I am making it void here. So this, where the aggrieved party approaches the court to make a voidable contract void, is called as recession. Section number 27. Very simple. So where a recession may be given and any party interested in a contract may sue to have it rescinded. Okay, in the following cases: it is voidable. Okay, it does not. Here we'll directly come here that when the court will refuse to rescind. Now why the court is not refusing? Because maybe the plaintiff must have accepted it, made it valid. So maybe the plaintiff must have ratified the contract. So he must have approved it. Later he is coming and saying I want to make it void. They're not allowed. There's a change in circumstances, okay, where the parties cannot substantially restore to the position where they stood when the contract was made. For example, now both the parties have done something more in the contract, and now we are saying that listen, it was a voidable contract, but this party has also done something, that party has also done something. Now there is a change in circumstances where we cannot restore it to the original position, so we will not order rescission. Okay, where only a part of the contract is sought to be rescinded and such part is not severable from the rest. So now let's say if you are asking where any part of the contract is sought to be rescinded. So what are you doing? That you want to rescind only the multiple contracts, or contract must be entered where there are multiple things. Out of that, one party want to make it rescinded. Recess you want to do. So that is allowed unless only if it could be separated from the entire agreement. If the small part could not be separated, then we will not order rescission for some and making the other part valid. So recession is for voidable contracts, to make it void. Simple. What is cancellation of contract? Now cancellation of contract is more serious. It is applicable to void and voidable contracts. One. And second, there could be a serious harm if left uncancelled. So imagine cancellation of contract means that when cancellation may be ordered where any party against whom, where it is void or voidable, has an apprehension that if left outstanding, if left uncancelled, it will cause serious injury. So very simple. Let's take an example. First of all, even if the contract is void. Now void, and you will say what is there? Now let's see, pay attention. I'll give you the example, you come to know. Let's say someone has taken my signature as an underwriter through fraud. Now my signature has come as an underwriter, or let's say as a surety. Someone has taken as a surety, guarantor. So I will say, listen, it was by fraud. Now fraud are void. But still, if left uncancelled or if left outstanding, someone might utilize this and I might have a liability and issue. So I will go to the court and cancel it. Okay. So very simple. Relief will be available when it is either void or voidable, and it is left outstanding will cause serious harm. Okay. Serious injury. So this line you have to remember, that void or voidable, and if left outstanding, it will lead to serious injury. This line you can write an underwriter example. Now what instruments can be partially cancelled? So a court will, same thing. Now very important thing is, okay, this is important, section number 33, that power to require the benefit restored or compensation to be made if it is rescinded. Now understand one thing. Now you are asking for cancellation of instrument. Simple pointer. Now there was a case where there was a minor and there was one person. This person, the minor, entered into an agreement. He said that I am giving a promissory note. He gave a promissory note that I will pay you so much money, you deliver your car. So the minor tried to buy. He became the buyer to deliver the car. Now this person didn't know that he is a minor, and then he sold off his car, and in return he got a promissory note. Later he came to know that this person is a minor and this contract is a void contract. So he can cancel it, but on cancellation he will say that, listen, I have delivered my car to the minor. The minor has received a benefit under a cancelled contract. Such benefit should be restored. So court can order the minor or will order the minor to restore the benefit got, the benefit that he has got. Simple. Let's read. Okay. What is the point? Power to restore the benefit given. So on cancelling, the court may require the party to whom such relief of benefit is given, that if any benefit has been received, to make or return the benefit or pay compensation to the other side. This is the most important thing. Okay. Then we are done with the next part also. Okay. We are done with recovery of movable immovable property. We are done with specific relief given. Third, we have also done with rectification, recession, cancellation of instrument. And now we come to a concept called as, the next fourth part is called as declaratory decree. So it is important, as come in the exam also. So declaratory decree means what? A person who feels that his house or his rights are going to be challenged. So he will go to the court and tell to give a declaratory decree. So declare by an order that he is the owner. So that if the doubts and all of this litigation cannot happen, because first only I go to the court, I say you look at my documents, you look at my title and determine my character in the property. So they will say, yeah, your character in the property is of a owner. Once court gives that decree, that order, that I am the owner, then nobody can challenge. So a declaratory decree is a decree whereby any right or legal character is judicially ascertained. So what is happening? Any right of a property, legal character is judicially decided or announced. The object of declaratory decree is to remove the doubt having with respect to the legal status and to perpetuate and strengthen the testimony regarding the title. So regarding the ownership will be cleared and protect it from adverse attacks. Now, under this section, the following conditions should be fulfilled. First of all, what is there for declaratory decree? That the person should have a right to a legal character, the person should have a right to be determined. Second, there must be someone who is denying the plaintiff right, so there has to be a hero, there has to be a villain, and then the declaration will be issued and the plaintiff will be entitled to the right to property. Then comes to the last part of the chapter, which is called as preventive relief. Okay, now remember, preventive relief is nothing but called as injunctions. What it is called? Injunction. So what is an injunction? I want you to write it down. Injunction is a order of court. What is an injunction? It's an order of court, ordering a person to do something or not to do something. Okay, to do something is a mandatory injunction. If they give a to do something, means it is a mandatory injunction, that mandatorily you have to do something. Not to do something is a prohibitory injunction, that don't do something. Court can order you to do something, that appoint the employee back is a order to do something. Not to do something is don't build one more building, stop the construction. That is a not to do something. Now this could be either a temporary or it could be perpetual. It could be temporary or it could be perpetual. Now temporary injunction is an order given in the very beginning of the case, basis of initial fact, that is prima facie fact, that listen, I feel this guy is right, so temporarily till the dispute is there, this will be the status, you do something. That's a temporary injunction. Now after all the facts have been heard, then a final order will be given. That final order is called as perpetual or permanent injunction. One of a temporary thing is, we can tell you that don't sell, don't damage the property till the final disposal of the case. So that's a temporary injunction. Now temporary injunction is covered under order 39 of CPC, whereas your perpetual injunction is covered under section 38 of the Specific Relief Act. Okay, and with that we've completed the entire chapter. Your question, in the exam, questions will have to be framed from here only. Nothing can come outside of this. Recovery of property, Specific Relief Act, against whom it can be given, against whom it cannot be given, rectification of instrument, recession, cancellation, declaratory decree and injunction. Done. With this we are done with the entire chapter. Thank you. Okay. So this is a heavy chapter but you know what I have done, if you do that much also you will be good enough. Normally this is a very heavy chapter, students find this difficult, and it is, but how much I have done, if you do that much, it is more than enough. Till here, clear everyone? Just write clear in the chat box. Yes or no? Just write the word clear and I'll move ahead. Now another chapter I'll do which I've never done before. Okay. Just write clear in the chat box so we can start with another chapter. Quickly. Yes or no? Plan to do one more chapter. I just need your support. Quickly, I'm covering everything. Whatever I do, then nothing comes outside of that. And I am not even taking fast pace. I'm covering everything in depth. Okay. So clear yes or no in the chat box. Quickly. Okay. Now we'll be taking one more chapter which is called as Indian Stamp Act. Okay. So we'll complete the Indian Stamp Act also. So we'll take a 10-minute break and we start. 10 minutes we start. Indian Stamp Act. Whether oh, there is noise. Hi guys, am I audible? Quickly audible in the chat box so I can quickly start. I just want audible and visible in the chat box so I can quickly start. Okay, great. Okay, great. So we will start. So am I audible and visible both together? So I will start and complete the chapter. Just write the word audible and visible. So I will complete the chapter for you. Quickly. Audible and visible, I want you all to mention in the chat box. Just waiting for your confirmation. Once that is done, I will knock off this entire chapter for you. Kirtana, am I audible and visible? Quickly. Okay, great. Thank you so much. Let's start. Thank you, thank you, thank you. Hi. So we start with a chapter called as Indian Stamp Act 1899. Now this chapter is pretty predictable and we know what all topics generally are asked from here. So I will be covering those topics important from exam point of view. Now when we first see what is the meaning of the term stamp. So stamp comes from is a word which means tax on documents. So certain documents require tax, that is stamp duty, to be paid. For example, your Indian Stamp Act under Schedule 1 contains that when certain documents are executed like sale deed, mortgage deed, stamp duty needs to be given. Okay, so very simple. You will open your Indian Stamp Act Schedule 1, see the type of document. If it is a mortgage, lease, any kind of sale deed, arbitration agreement, affidavit, all those things. Besides that, stamp duty will be mentioned. Let's start with the sections. Now, section 3, 4, 5, 6 are important. Let's see. Section 3 says is the charging section. It gives the power that when stamp duty will be levied. So, stamp duty provides that subject to the provision of the Act, stamp duty will be levied on all documents specified in Schedule 1. So, what? Stamp duty will be levied on all documents specified in Schedule 1. This you need to note. Some exceptions have been given. Okay, so stamp duty is not applicable for them. So the exemption from stamp duty is given that any instrument, now understand, when government is entering into any document, instrument, purchase of property, they will not pay stamp duty. Why? Because they will not remove from one pocket and pay it in the other pocket. So any instrument executed by or on behalf of Government of India, that will not require stamp duty. All three you see is related to government only, Merchant Shipping Act. So any purchase of any ship, vessel or any part of it merchant shipping app is again under the government of India for the Navy. So that is also not requiring any stamp duty because stamp duty is paid to government. So when government makes a document, they will not pay it to themselves. So they are exempt from stamp duty. And third is any instrument executed in the SEZ area. Now SEZ area for the purpose of tax are exempted and therefore no stamp duty is leviable. Now we go to see some instruments which may be chargeable for stamp duty. As I told you, any partnership deed, sale deed, share transfer forms, also gift deed, etc. are all covered. Now we are going to see section 3 is done. Section 3 is the charging section when stamp duty is levied on all transactions and documents mentioned in schedule 1 subject to certain exemptions. Now we see your several section 4, 5, 6. 3 we did. Now section 4. Several instruments in a single transaction. So several instruments are there but for a single transaction. So single transaction, multiple instruments. Such situations are covered under section number 4. Let's see what is the provision for it. First, then we'll see section number 5. Section 5 is the other way around, that there are single transaction, multiple documents. So for an instrument, so there is a single document for multiple transactions. Then we will see how is the stamp duty levy. This is covered in your section number 5. Section number 6 says when there is a confusion with respect to which entry it will fall in. Okay, so where we don't know a particular instrument is falling under different heads, then which if it is falling under 2 or more heads, then what is to be done? So maybe there is an instrument, it is falling under head 1 and head 2 of schedule 1. So we are confused, we don't know what to do. So section 4, 5, 6 we will be seeing. Very simple. So now what is the provision and how stamp duty is to be levied where you are doing one transaction and multiple instruments are involved. For example, there is a sale deed and for sale of the property a NOC is required. So can I say that you require a sale deed? Along with that a NOC of one of the brothers is also taken. NOC document. Now for one transaction, that is a sale of property, more than one instrument was made. So they say that you please pay on the principal document. On the principal document will be chargeable to the duty as specified in schedule 1, and for all other instrument, other like your NOC, any other document is there, will be charged with only rupee 1. So section 4 says that if there are one transaction requires multiple instrument, pay only stamp duty on the principal instrument. Rest all the other supporting documents will go with rupees 1 stamp duty. Sir, beautifully explained. Let's go ahead. Section number 5 says there is a single document containing multiple distinct transactions. They are containing distinct transaction. Means what? I made a sale deed, but in the sale deed I have immediately made a lease agreement also, that I am purchasing the house and then I will lease it out to XYZ person. So what is happening in a single document? There are happening multiple transactions. So how will the stamp duty be levied? Now stamp duty will be levied on the aggregate of such transactions. So the stamp duty will be levied on the aggregate of these transactions, okay, with which each such instrument would be chargeable. For example, I will find out what is the stamp duty on sale deed and what is the transaction stamp duty on lease. Aggregate amount of stamp duty will be levied on this particular document. This is held for multifarious instrument. Multifarious means distinct transactions in single document. Very simple, very easy. Now the third one is a case of section 6, which talks about one instrument falling under two different heads. We don't know whether it is a MOU or it is a sale agreement, whether it is a lease or a leave-in license. So when the character of the instrument is in question and it is falling under more than one head, then obviously government will say that whichever head has the highest stamp duty, that should be levied. So when a particular instrument is chargeable with different duties, then we will levy the stamp duty with the highest. Okay, so chargeable, so we'll levy it with the highest rate of stamp duty. So in this we'll find which is the highest rate of stamp duty, we'll apply that. So under section 6, okay, the act provides that where the instrument shall, where the duties are chargeable at different rates, then the highest of those rates will be taken to protect the levy of, to protect the interest of revenue. No loss of stamp duty should be there. So we finish section 4, 5 and 6. What does 4 say? That there is multiple transactions for multiple instruments, multiple documents for single transaction. Then what we do, we take on principal document, we take the stamp duty, and on other documents we take ₹1. When it is under section 5, then what we do, we take the aggregate of stamp duties on all transactions, and in this what we do, we take the highest of the stamp duty. Very simple, very easy. Let's move ahead. Okay, so section 3, 4, 5, 6 we did. Now we are seeing who will end up paying the stamp duty, who is liable to pay stamp duty. So the topics that is important will tell you. So normally if stamp duty is there, okay, and nothing is mentioned, normally parties will say that we are putting half we are doing. But if that is not mentioned, then by default, imagine if I am purchasing the house, I will pay the stamp duty. Na? In case of instrument, any of the following instruments, it will be made by the person making it. If an insurance policy is there, then the person who, for whose benefit the insurance is being taken. If it is a fire insurance, by the person issuing the policy. In case of lease, then the lessee will be done. In case of sale document, the purchaser will do the thing. Okay. In case of partition, then those in proportion to their share will have to pay the stamp duty. Now, stamp duty are of two kinds. Now remember this, method of stamping. Method of stamping, that is section number 10. It says two types of stampings can be there, adhesive stamping and impress stamping. Adhesive means what? Here this is your bill of exchange. We put a stamp here. So this is a stamp where you stick it. The stamp is stuck. So that is called as adhesive stamping. Impress stamping is something like this, where you have 100 rupees non-judicial. So this comes in documents where you have your affidavit, sale deed. Most of your documents will come in impress. They've given you what comes in adhesive, rest all comes in impress stamp duty. Even your articleship, when you will do, will be on impress stamp paper, where your entire agreement will be printed on this stamp paper. Okay, let's see when this adhesive stamp paper is used. So section 11 says when we use adhesive stamp paper. So it is used whenever the instrument is chargeable with a duty not exceeding 10 paisa. So maximum 10 paisa is there. Bill of exchange, we have seen from 11, 12, when we draw bill of exchange, we put a stamp duty adhesive. When a advocate is being appointed as a wakalatnama, always they also stick the on your, when you appear in court, lawyers have this stamp duty, they put it, those stamps. Notarial acts, notarial means notary, when you go to do, you will see this kind of stamps. And endorsement of shares also. Now coming to the next one is cancellation of adhesive stamps. Now we saw that adhesive stamp, when all it is used, now it is required to be cancelled. It is cancelled by at the time of signing or before it, and it is done by putting two juggled lines against it. Why it is done? To prevent it from being reused again. So when you see any stamp, okay, you put it, it is your duty at the time of signing or any time before it, you put these juggled lines. So nobody will reuse this particular stamps. Simple. In this case, it was held as stamp duty. Stamp may be treated as having being effective or cancelled by merely putting the crossed lines against it. Simple. Then we come to the concept of denoting duty under section 16. Denote the duty means what? To mention it there. Denote means to note. So noting of duty will be done. It will be noted that. Now when it is done, normally when I have some previous documents, my stamp duty is my determination of my stamp duty depends on some previous instruments also, whether you pay the earlier rents or no, earlier stamp duty. So I will say every time I have to bring the other previous documents. Instead, just denote it. I'll go to the officer. I'll tell the officer that see, all my previous year's stamp duties have been paid. You just denote it here in 2025 document that I have paid 2021 to 2024 stamp duties have been paid. Denote it. So in 2026 when I go, I don't have to bring all the previous documents. So the objective is to spare the parties the inconvenience of having to produce the earlier documents to prove that the original stamp duty was paid. So denoting means I'm telling the officer that just denote the past ones are paid, so I can just bring that note, that denoting duty, whatever certificate you give me, I'll present it. So I just have to pay the current year's stamp duty every time. I don't have to produce the original thing. Where a duty with which an instrument is chargeable depends, so I have to identify how much stamp duty is there. That identification depends whether another instrument has been duly paid or not. So then we can give in application can be made to the collector of stamps that you please denote it, specify, indicate upon the document that the earlier stamps have been properly paid. Okay. Now coming to the next thing is time of stamping. When do you have to stamp the document? So this is important. Okay. Stamping, as we saw, has to be done on or before the time of execution. So obviously while we are signing the this thing logically, stamp paper must have been bought and then the agreement must be printed and signed. So it will be any time before signing, right? Common sense, because you will sign on the stamp paper. So stamp paper, before that only it has to be done. Instrument, if it is outside India. Now imagine if the document or agreement was made outside India, then it may be stamped within 3 months after it was first received in India. So after its first 3 months of its arrival in India, this will be done. Okay. Now instruments not duly stamped, section 33. So if a particular document is not sufficiently stamped, then the officials will impound it. Impound it will take some action. They will put penalty, etc. So if an instrument is not duly stamped, common sense, he will take action. He will tell to pay the deficient amount on the duty. This is power is given to the officer to impound, means to correct, to enforce the payment of stamp duty, is to protect the interest of revenue. Simple. Now very important, you need to know with the section number. Instruments not duly stamped inadmissible as evidence, section 35. So we can mark it as important. Okay. What is it that what if I don't pay stamp duty? So then it will be, you can remember this. Okay. What does it say? It will not be admitted in evidence. It shall not be acted upon. Okay. It shall not be registered, and it will not give any power authenticated by the police officer. It will not be registered, cannot be acted upon, cannot be admitted as evidence. It cannot be taken as evidence. It cannot be acted upon. It cannot be registered, and no police officer or public officer can recognize that document. So just remember these 4 points. If a document is unstamped, cannot be taken as evidence court, no one can act upon that document, cannot, registration officer will also not accept it, and last, any public officer will also not approve it. Very simple. An insufficiently stamped instrument is not an invalid document. Document is perfectly valid. It can be admitted in evidence after payment of penalty. So market is important. That if I have not paid stamp, it doesn't mean that the entire agreement is invalid. I have to pay the stamp duty and then it will be taken as evidence in court after I pay the stamp duty and penalty. Done. Then one important thing, let's see, section 24, how consideration of debt is to be charged. Now understand one line. consideration, how transfer in consideration of debt is to be done. So in case of sale, any property subject to a mortgage. So property subject to a mortgage, any unpaid mortgage money, okay, shall be deemed to be a part of the consideration of the sale. What does it mean? That in case of a consideration of sale subject to a mortgage means one is the mortgager who was the original owner of the property. He has mortgaged his property to the mortgagee. Mortgagee could be the creditor or the bank who has given the loan. Now what is happening is the creditor wants to buy up the property. Let's say the mortgager paid 50%. He paid 50%, 50% he couldn't pay. He said that you just give me my 50%. Okay, you give me the balance amount and you become the owner of the property. So let's say 1 crore is a flat amount and 25 lakhs I had taken a loan against that. I cannot repay. I cannot repay the loan. So I say that I'll tell the mortgagee that listen, you pay me the money and you take the house. Ownership, you take it. So he says, okay, fine. So what is happening is you are selling a property subject to a mortgage. Then the unpaid mortgage money, okay, obviously now the owner is saying that I am not going to pay you that unpaid mortgage money. You consider it as a consideration for sale. Okay, so what is happening is I am telling the bank, listen, I owe you 70 lakhs more. You take my property and you adjust that 70 lakhs. So they say, okay, fine, we'll adjust it. So let's say the bank or the creditor, okay, is coming in and he's saying that the property value is 2 crores and let's say 75 lakh debt is left, debt is outstanding. So what I will say as a owner that listen, one thing is I will sell the property to you. So normally I would have sold it, I would have got 2 crores, but I will not get 2 crores. I will subtract 75 lakhs because this will get set off and only 1.25 crores transaction will be done. So the property is of 2 lakhs. I have taken a loan of 75 lakhs. Now I decide that I want to sell it. So I go to my creditor only. I say this is a 2 crore property. I will sell it. You don't have to pay me 2 crores. You pay me 2 crores minus how much money I owe you. So I owe you 75 lakhs, subtract that and do it. Okay. So now this amount will be allowed. So set off allowed. So first line you have to remember, set off is allowed. Second, the stamp duty. Now we are the concern with stamp duty. Now stamp duty, I pay on 2 crores or I'll pay on the balance amount. So stamp duty, they will say you have to pay on balance amount. Why? Because on this amount also you must have paid now for mortgage. So first we will calculate on 2 crores. Stamp duty is let's say 10 lakh rupees. Then I will say listen, 75 lakhs also you paid. Now how much stamp duty you paid? How much it is, I will subtract it and balance amount of stamp duty you will have to pay. So remember the unpaid mortgage money which I have not paid, which is I have to pay the creditor, I'll just treat it as a part of the consideration of sale. Okay, and I am allowed to deduct the stamp duty payable which I have paid on the mortgage. Okay, simple. Then comes e-stamping. E-stamping is electronic stamping. Okay, and benefits of stamping is a government website, you can go and stamp it. Now one is a concept of stamp. So stamp is basically a mark, a seal or bearing the government authority. Duly stamped means properly stamped, you pay the proper stamp duty. Okay. Conveyance, the meaning of the term conveyance means it's an instrument, it is an instrument where property is transferred. Property is transferred. This property could be movable property or it could be immovable property. Okay, so that is called as a conveyance. So whenever I sell a house, I sell a car, movable or immovable property, it is called as a conveyance. Okay, with this we have completed the entire importance from your Indian Stamp Act 1899. Thank you. Till here it is clear, yes or no? Yes or no? Till here it is clear? In the chat box I want you all to write clear or no. Waiting for you all to message whether I'm audible, I'm this. Okay, so someone has asked a question that great. If an instrument is executed on a public day or after the hours, does the time limit under section 17 for stamping, that is before or at the time of apply strictly? Yes, it still applies. So the answer is still applies. Yes. So the time limit still applies given under section 17. Yes. Madhu, ask your question. Okay, so I've covered all the important things that normally come from Indian Stamp Act. Normally students find it very, very irritating not knowing what to study and what not. So I've given you the importance as well. Okay, any other doubts, questions? Okay, so now what I plan to do, now pay attention. Tomorrow I will be taking, okay, your other important chapters, but I will start earlier. I will start at 11:30 a.m. only. Okay, and first thing I will complete is your Evidence Act. Evidence Act I will complete. That is your BSA Act I will cover. I will cover even your other important chapters too. Other important chapters also I'll cover, but I'll start earlier tomorrow. I'll start early tomorrow at 11:30. Clear till here? And I'll try to complete early also. Okay, so even if an instrument is accidentally understamped, section 17 timing still applies. However, later it may be rectified by paying the deficient amount which is there. You can pay the deficient amount. So yes, the timing still applies. Okay, so let's see. So what is the question? That even yes, stamp duty under section 17 must be paid before or at the time of the execution. That is there. Yeah, it is not deferred until the second party signs. It doesn't defer till the second party signs. It is even on the immediately starts from the date of signing. Okay, so this is it, guys. I will complete tomorrow. The first thing I will complete is your BSA Act right in the morning. The notes also for this I will share it in the group. Till then you can study from your particular dream batch. I've given you access to almost all the lectures. Okay, I think one more doubt has come, that what if you have paid the stamp duty in a void document. Now there is a provision which says for refund you can claim for this. Okay, so when you paid on void, you can ask for your refund of stamp duty. So there is one small point which you can note from here. Okay, this is from where the question has come. See, let me take you through one point. Yeah, so you can refund of stamp duty is given in the following cases. that when you can ask for refund of stamp, maybe it was spoiled stamps, it was misused, unused stamps, or you've paid in excess of which is required. So in that cases you can claim a refund. Okay, so that is it, guys. We are done for today. I will see you all tomorrow 11:30 and I will cover the important chapters also. So the chapter that I am planning to target in the morning for you, just for knowledge sake, I'll tell you both important chapters. First is I'll cover a Indian Evidence Act, and then I will also take your Arbitration Conciliation Act. So these two itself are heavyweight chapters. I've almost covered your full syllabus. You see my first marathon and this marathon and tomorrow's marathon, more or less the full portion is covered. Okay, so with this I am done. Wish you all the very best. Sleep early and get up early, and I will see you all tomorrow at 11:30 a.m. And just one more thing is, do write exemption in the chat box. The purpose is you should know what you are targeting from the very start. So if you see all these athletes, they are there, what happens is they train their mind that they are bound to win. So because of that training, that neurological understanding, the brain already is prepared for success. So that's why I'm saying always keep writing exemption, and you will see that exemption will be there in your mark sheet as well. So with this, good night everyone. I will see you all tomorrow and cover the other chapters also for you. Thank you. Great. Madhu, exemption 60 plus. Great. You all can write exemption. Let your mind know exactly what you're targeting, and you will see it in your paper. Great. Good night everyone. All the best. Finish the chapters that I've done. Even I've taken in chapters normally where students find difficult. So you know which are big also, but you will know which all are the important stuff. Good night. Kirtana, great. Bye. Bye Ashley. See you all tomorrow at 11:30. I'll come.